Thank you, Mr. Chairperson. Old Wage, I'll spell that. It's OLDWADGE.
Yes.
KC.
Yes.
Is my name. I'm a member of the Johannesburg Bar. I appear on behalf of Mr. Gama.
Yes.
I'm instructed in this matter by Brian Khan Incorporated. Ms. Barker, seated to my right,
Yes.
from the aforesaid firm, is in attendance with me. I have appeared before you in these proceedings.
I think I remember.
Indeed.
Yes.
Thank you, Mr. Chair.
Thank you very
We're
much.
merely here to observe today, and
Yes.
there may very well be an application that follows the testimony.
Yes. Okay.
Thank you. I'm indebted.
No, that's fine. Thank you.
Mr. Chairperson, if I could just take a few minutes to sketch the
Yes.
background then to Mr. Todd's evidence.
Yes.
The name GNS, General Nyanda Security, has featured in these proceedings when Mr. Todd first gave evidence. You will recall that Mr. Gama was dismissed as the Chief Executive Officer of Transnet Freight Rail on a number of charges of misconduct. He was found guilty inter alia of negligent conduct in relation to his signature of the confinement tender in favor of GNS. They were then appointed as a security provider at Transnet. So evidence has been given by Mr. Todd in that context. Today, the focus shifts to evidence by Mr. Todd relating really to the propriety of the contract and ultimately the settlement of litigation that ensued between Transnet and GNS. Between the time that Mr. Gama was dismissed and reinstated, Transnet instituted legal proceedings against GNS where they effectively reclaimed, I beg your pardon, the 95 million rand that had been paid to GNS during the course of the contract after they had terminated it. Sometime after that, by which time Mr. Gama was reinstated, Transnet and GNS, or Nyanda Security, its successor in title, entered into a settlement agreement in terms of which Transnet withdrew its application and agreed to pay costs on an attorney and own client scale. And ultimately...
Was it not an action?
It was an action,
An
yes.
action, yeah.
An
A
action
claim for damages that
Correct.
Transnet had instituted against GNS.
Yes.
Yeah, to recover effectively money that they had paid to GNS pursuant to the contract that Mr. Gama had approved.
Yes,
Yeah.
correct. Allegedly an irregular contract.
Yes.
So that action, Mr. Chairman, you correct, it was an action, it was withdrawn, and then there was an agreement to pay costs on an attorney-client scale. That litigation was still at quite a premature stage. There had been an exchange of pleadings, and I think the filing of a discovery affidavit. Ultimately, Transnet paid some 20 million rand in costs. So Mr. Todd's evidence will give you insight into alleged irregularities in relation to the conclusion of the contract, irregular performance under the contract, the decision to settle, and the decision to pay the 20 million rand costs. The other leg of Mr. Todd's evidence relates to the third payment of legal costs made to Mr. Gama further to his reinstatement. The background to that, you will recall, Mr. Chairperson, when Mr. Gama was reinstated, it was agreed that Transnet would pay 75% of his costs in relation to the High Court application and referral of his dismissal dispute to the Bargaining Council. Now, what we know...
And it was a taxed cost, huh?
That, yes.
Yes.
What we do know is that Mr. Gama was paid that, but then he was paid more. He was also paid 75% of the costs that were incurred by Transnet by two separate sets of attorneys and counsel in the High Court proceedings. When Mr. Todd and Mr. Mpoma gave evidence before, because Mr. Mpoma dealt with the costs issue, we did bring to attention that a year or two later, there was in fact a third payment that was made in respect of Mr. Gama's legal costs of some 1.5 million. Mr. Todd has undertaken an investigation in that regard. He's been provided with the documents and he puts up a short affidavit, which he will also speak to, but that part of his evidence will be very short. Unless you have any questions, Mr. Chairman, might I call then Mr. Todd as a
Yes, thank you. Good afternoon, Mr. Todd. Thank you once again for coming back to assist the Commission in regard to this matter. We appreciate the fact that you have assisted the Commission to understand exactly what happened in regard to these matters. Thank you.
Thank you, Chair.
Please administer the oath of affirmation.
Please state your full names for the record.
Christopher Francis Neil Todd.
Do you have any objection to taking the prescribed affirmation?
No, I don't.
Do you solemnly affirm that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you. You may be seated, Mr. Todd. Mr. Mybeck, the latest affidavit of Mr. Todd that deals with the bad payment.
Yes.
I read it yesterday. It was separate. I wonder whether it is now in this bundle because I don't see it separate.
Yes, it
is
has
in
been
that
added to that bundle.
Okay, all right.
Mr. Chairperson, as you know, Mr. Todd's affidavits are contained in Exhibit 17, which is, I think it's marked as Bundle 3, and that contains Exhibit BB 16 and Exhibit BB 17.
I guess we should start by saying that we will be using Transnet Bundle 03.
Yes,
Is that right? And then the various exhibits are in that bundle?
yes.
Okay, all right.
So it's the various affidavits of Mr. Todd appear in Exhibit 17. If I could, before I get to the detail of them, just sketch this.
Yeah.
Mr. Todd has now produced 5 affidavits. The first affidavit, which has already been admitted into evidence, deals with Mr. Gama's reinstatement. The second affidavit that's also been admitted deals with the issue of condonation, the basis upon which Mr. Gama was reinstated. You will recall, Mr. Chairperson, that right at the end of that affidavit, Mr. Todd also gives a bird's eye view, really, of GNS. Mr. Todd then has produced a third affidavit that deals with GNS. He produced a fourth affidavit which deals with GNS, but just the payment of costs. That's a very short affidavit. And then the fifth affidavit deals with the third payment of legal costs made to Mr. Gama after his reinstatement. So I'm going to take Mr. Todd now to his third, fourth, and fifth affidavits, and then I'll ask you as we go along to admit them into evidence.
Okay, that's fine.
Mr. Todd, do you have in front of you Bundle 3, Exhibit 17?
Yes, I do.
Could I take you, please, to page, and as you know, we refer in evidence to the black numbers. Could I please take you to page 486, 486. Are you there? And perhaps I could ask you to turn to page 508. Would you confirm that this is an affidavit of yours together with a series of annexures running from I all the way through to, I think it is NN at page 797.
Yes, that's correct.
Would you confirm then, if you go back to page 508, that it's an affidavit of yours deposed to on the 25th of September 2020?
That's correct, yes.
And would you confirm again under oath the accuracy of this affidavit?
Yes,
and
I can.
truth and accuracy?
I can confirm it.
Mr. Chairperson, might I ask you then please to admit Mr. Todd's affidavit of the 25th of September 2020 as Exhibit 17.3.
Thank you. You said that one is the one that begins at 486
Yes.
and goes up to 508. And then it
Go.
has annexures.
Yes, and the annexures run all the way to 797, Chairperson.
Yes, okay. What exhibit number will it be?
17.3.
There is no letter before 17?
It would be BB 17.3.
BB,
Yes.
okay. The affidavit of Mr. Christopher Francis Neil Todd, starting at 486, together with its annexures, is admitted and will be marked as Exhibit BB 17.3.
Thank you, Chairperson. Mr. Todd, could I now take you please to page 798? Are you there?
Yes?
And then if I could take you to page 800, this is a short affidavit. Would you confirm that this is an affidavit of yours, including a series of annexures that run up until page 840?
Yes, that's correct.
And that you deposed to this affidavit on the 7th of October 2020. Would you confirm the truth and accuracy of the affidavit?
Yes, I did, and I confirm its contents.
Mr. Chairperson, could I ask you then please to admit this affidavit as Exhibit BB 17.4?
The affidavit of Mr. Christopher Francis Neil Todd, starting at page 798, together with its annexures, is admitted and will be marked as Exhibit BB 17.4.
And then finally, Mr. Todd, could I ask you please to turn to page 841? Are you there?
Yes.
This is an affidavit that runs through to page 847. It contains a series of annexures running up until page 879. Would you confirm that you deposed to this affidavit on the 7th of December 2020? And would you again swear and confirm its truth and accuracy?
Yes, I confirm that I deposed the affidavit on that date, and I confirm its accuracy and truthfulness.
Mr. Chairperson, could I ask you please to admit this affidavit then as Exhibit BB 17.5?
The affidavit of Mr. Christopher Francis Neil Todd, starting at page 841, is admitted together with its annexures and will be marked as Exhibit BB 17.5.
Thank you. Mr. Todd, so what's been admitted now into evidence are your third, fourth, and fifth affidavits. We may, during the course of your evidence, go back to your first affidavit, which has already been admitted. But could I take you, please, to the affidavit, Exhibit BB 17.3, at page 486.
Yes?
Now, you previously gave evidence about what Mr. Gama said about his signature of the original confinement tender. But perhaps we could just, I'm not going to ask you to rehash that, but could we start at paragraph 4, just to formally place on record the signature of that document by Mr. Gama?
Yes, Chairperson, that document was the original confinement document that was approved and that initiated the appointment, or was necessary to initiate the appointment of GNS. The document itself appears at page 509. and the pages that follow. And the signature page of that document is at page 515. So that is the document which sets out if one looks at page 509 at the start of it, that is the document that sets out the title of the submission is a confinement. The heading at the top was confidential GNS confinement. The recommendation, which sets out the reasons for issuing a confined tender, is then explained. And they talk about how, and I don't want to repeat the evidence, there was an ongoing tender process which was stopped, and this document records.
Well, it might not be a bad idea just to go back a little bit, just so that even the public that's listening, they can follow.
Yes.
Without going too much back, just the context, so that the public can follow your evidence correctly.
Yes.
Yeah.
Thank you, Chairpersons. So what this document in fact summarizes is that there had been a public procurement process, a competitive bidding process, and as I gave evidence last time, GNS was not one of the bidders. It was not involved in that process. That process was then stopped.
And this was a tender for the provision of security services.
Of security services.
At Transnet.
Yes.
Yes.
Yes, and as I said last time, it was a tender which everybody agreed, and Mr. Gama was quite emphatic about this, that it was not suitable for confinement because there were so many available public providers of the service. And his evidence was, had he known the true facts, he would never have approved this confinement. And as I explained last time, he said he didn't read the document, he just signed it. But the document itself explains the background, it explains that it's a confinement, it explains that there had been a public tender process that had been stopped, and it then says, and I'm reading in the second paragraph, next to the letter 2 on page 509, in that block, fourth paragraph from the bottom, it says, a research of potential companies was conducted, and General Nyanda Security, GNS, was called in to do a presentation in a form of a proposal. And then it explains that their GNS's proposal was in content with our required solution, etc., etc. They were highly recommended, and so on. So this document really is the original motivation for the confinement, and it was originally intended to be 5 months subject to a review, and that's explained over the page at page 510, next to paragraph 4, which talks about the contract period, and it specifies there from 1 November to 30 April 2008, 5 months on a performance review period, and then it says the total contract period is 1 year, from 1 November to 31 October 2008. And then it sets out the pricing, it sets out a commercial evaluation, who approved it, technical evaluation, and the name of the company itself, the tenderer, at page 511, is General Nyanda Security Pty Limited. The directors are set out there as being Sylvester Sitole and General Sapiwe Nyanda. Over the page on 512, the BEE requirements are set out, and it says percentage black ownership of the tenderer is confirmed as being 100%, and so on. And then the signatures eventually are appended at page 515, and they're really a series of approvals, the last of which is Mr. Gama's approval, which was given on the 5th of December in 2007.
Paragraph 4, initially talks about the period being 1 November 2007 to 30 April 2008, which is not a year. But it says in the next sentence, total contract period 1 year, 1 November 2007 to 31 October 2008. Is there an inconsistency there or not?
Well, it's a strange provision because it says it's a 1-year contract, but it also says it's 5 months on performance review.
Yes.
The only time that was raised was this, one of the complaints, one of the issues was that this contract, its annual value, which on the initial pricing of it was estimated to be 18 million rand as an annual value, and you find that if you look at paragraph 11, that exceeded Mr. Gama's authority, which was a 10 million rand authority. And Mr. Gama said, no, I actually only approved 5 months, which fell within the 10 million authority. Now, whether that was the intention of putting a 5 months in there, if the officials were alive to the 10 million issue, they may well have inserted that 5-month review period in order to give an argument that it fell within Mr. Gama's authority. As it happened, this contract, in fact, doubled in value inside that 5-month period and was then extended further. And as we know, it continued for 25 months at a total cost of 95 million. But its origins, certainly at a time, Mr. Gama said that having only approved the first 5-month review period, it actually fell within his levels of authority. But that argument wasn't really available to him once he said in his disciplinary hearing that actually he never read these documents and just appended his signature. So I don't know, he would be able to explain whether he relied on that or not.
It's quite strange, and of course the chairperson of the disciplinary hearing made certain findings, but it's most concerning that the chief executive officer could sign a document committing a company to to millions of rands without reading the document, to the extent that he says he was approving a contract that would run for 5 months when in the document there is a reference to a year. Yes. So you sign something that you can't explain yourself. So is this contract for 5 months or is it for a year? Because in the same document you have got a reference to a year, and then you have got a reference to 5 or 6 months.
Yes.
Yeah, okay.
Yes, that was the finding of the chairman as to why he said it was serious negligence for a chief executive and justified dismissals.
Yes. Yes.
Thank
Mr.
you.
Mybeck.
Mr. Todd, if I could take you back to page 487 of your affidavit. You've already touched on this. You've mentioned the disciplinary proceedings that were instituted against Mr. Gama. One of the charges that he faced, you deal with this at paragraph 5, related to his signature of this confinement. You then go on to explain what Mr. Gama said, and some of this you've already touched on, about his signature of that confinement during his disciplinary hearing. You attach the transcripts of the hearing, and you deal with this at paragraph 7. This is also evidence that you've given before, but perhaps in line with the direction given by the chairperson for the sake of the public, could you just summarize or paraphrase for us what Mr. Gama said about his signature of this confinement during his disciplinary hearing?
Yes, chairpersons, if I may just make it clear, the full transcripts run to many more pages. The inquiry ran over, I don't recall the exact number of days, possibly 7 or 8, and not all of the transcripts are attached. That would have, it seemed to be very, unnecessarily paper heavy. But these transcripts do show certain things, key things, primarily what Mr. Gama actually said in the disciplinary hearing. And it deals with, in paragraph 7 of the affidavit, deal with one point which we have already canvassed, which is the relationship between Mr. Gama and General Nyanda, which was a matter of concern because it was alleged by Transnet in the disciplinary hearing of Mr. Gama that there was a personal relationship. And Mr. Gama said, put it through his counsel, through cross-examination, that there was no such personal relationship and that he knew General Nyanda like any other member of the public would know him. And what then happened was that the Transnet produced Mr. Gama's cell phone records, which showed various telephone calls between Mr. Gama and General Nyanda in the period immediately preceding the award of the contract. And in fact, as I point out there, the most recent phone call between them had been on 1 December 2007, which was 4 days before the contract was signed. What Mr. Gama was obviously called upon to explain this discrepancy, having said that he didn't know General Nyanda, but then having to explain why it was that he'd been in touch with him. And he then said that, and this is explained, and this is the portion that's reflected in these transcripts, the portion of Mr. Gama's own testimony, where he said that he had in fact given his counsel in the inquiry incorrect instructions because he had wanted to put some distance between himself and the general, and he admitted that that had been wrong, and he apologized to the chairperson, and he then stated that General Nyanda was not a close friend, but an acquaintance with whom he had played golf in the past, with whom he had spoken on the phone when there were family bereavements, and who had called him to commiserate when he'd been suspended. So he explained that as being the nature of that relationship between him and General Nyanda. The significance of that, of course, was that the company that had benefited from the confinement, in fact, bore General Nyanda's name. It was General Nyanda Security. And obviously that was something which created quite a strong inference that Mr. Gama was in fact aware and party consciously to granting an irregular confinement. But Mr. Gama's version, as I've said in the inquiry, was then that he knew General Nyanda but had no idea even that the contract was in favor of General Nyanda Security. And he then said, and this is summarized in the affidavit, he then said that actually an official had come and asked him to sign the document without letting him read the document, and it had explained the document completely differently, had not told him who it was in favor of, and had said it was the product of a full open tender, and that he was merely confirming the appointment of the successful tenderer after a public procurement process. So that was the evidence he gave in the hearing, and including that he hadn't read any part of the document. And what then really is important also from those extracts is that in the disciplinary hearing, when it was put to him, but Mr. Gama, you now can see this confinement document which you signed is written all over it that it was a confinement, and it's written all over it that it's in favor of General Nyanda Security, the amount exceeds your authority, and various other irregularities were brought to his attention. And it was then that he said in the inquiry that in fact, now having been shown all of this, he realized and could smell something fishy, and that he realized that this was in fact fraudulent. It was a complete fraud, and that he now realized what the scam was all about. And by this scam, he was referring, if one reads the evidence, to the way in which this procurement occurred, which he described as a scam. And what he said, though, was that he was an innocent party in the scam. He hadn't realized he had been manipulated by officials who had, as it were, pulled the wool over his eyes. So that was the evidence, and when he was asked in those portions of the transcript, one can see he's asked, well, who should be accountable if you signed this document and it was a fraudulent scam? And he then pointed to various officials, two of whom had already been dismissed, in fact, one Mr. Senamela and a Mr. Kanya, and the other person he suggested should be held accountable was a Mr. Beatty, who had in fact presented him with the document and who by then was living in Australia. So that's what we deal with here, and that really leads to, I think, the point that this contract with General Nyanda Security, rather than being cancelled and the money recovered, it was cancelled, but when Transnet sued for the return of the money it had paid under this contract, two things happened. One, Mr. Gama was reinstated into his employment, and then through a series of, over a period of time, the management of Transnet gradually, effectively poured cold water on the litigation and ultimately persuaded the board that it was appropriate to withdraw the litigation.
But the transcript of his evidence in the disciplinary inquiry that you have referred to, would my understanding be correct that what he in effect was saying when he said that he had given his counsel incorrect information about the relationship between himself and General Nyanda, because he wanted to create a distance between himself and General Nyanda, that in effect he was admitting to having given his counsel untruthful information?
Yes.
To use to challenge the evidence of witnesses?
Yes, Chairperson, that's exactly what he did.
That's what it means.
Yes, so that's what he apologized for having done so. He
Yes.
accepted that that is what he was doing.
And
he
but
said
he
it was
only
wrong. He said it was
apologized
wrong of
because
him.
he was caught out,
Yes.
because the telephone records were produced. And then he was in a corner. He couldn't deny the telephone records.
That is what happened, Chairperson. That's correct.
Yes. And at the disciplinary hearing, as I understand the position, everybody agreed, including him, that there was no basis for General Nyanda's company to have been awarded this contract on the basis of a confinement. In other words, without an open tender. Everybody accepted that.
Correct. Mr. Gama was very clear on that. He said he would never have signed it if
was
he had
an
known the true
irregularity.
facts.
And of course, that just helps to compound the whole subsequent withdrawal of the action, which you will deal with in due course. Okay, all right, Mr. Mybeck, you may continue.
Thank you. Mr. Todd, you go on in paragraph 9 to explain that the finding of this hearing, as well as the finding of the Kassim inquiry, which dealt with Mr. Sanamela and Kanya, which we dealt with last time, formed the backdrop to the civil claim. You also mention in paragraph 9 that what was also relevant to bringing the claim was the inability to obtain information from GNS as to what they had actually done under the contract. And you say at paragraph 9 that this is something that you deal with in your first affidavit, and you refer to paragraph 37A to E. Could I just take you there, please? 37A to E in your first affidavit, you find at page 61.
Yes, yes, Chairperson. Really what I dealt with there is the irregularities in the appointment, which ultimately were confirmed by Mr. Gama, that the appointment itself had been completely in breach of the procurement regulations and had arisen, as was very clear, particularly in the inquiry involving Mr. Senamela and Mr. Kanya, had involved collusion between, it was put rather coyly in the confinement document that there was research done and that GNS was identified. In fact, there were emails exchanged between the Transnet officials and GNS in a way that's described in the finding of the chairperson in that inquiry, which showed that Transnet helped GNS to compile its proposal, and that in fact GNS, contrary to what it said, it had zero track record, and it had adopted, really plagiarized from American security companies in pitching for its, its long track record and experience. There were a whole lot of indications that this was a completely irregular a contract, which, as I said, Mr. Gama used words like fraud and scam when he was confronted with what had actually happened here. And that was what had happened at its inception. In fact, the contract was then doubled in size quite soon afterwards, and I'll come to that in a moment. And ultimately led to the total cost being, the total amount paid to GNS being 95.5 million rand over just over 2 years, 25 months. The total amount paid is 95.5 million for those 25 months. But the piece that is then dealt with, and this is what is really important to understand how this contract was, so I've said and have given evidence about the irregularity in its inception, but what became equally of concern was the irregularity of its execution. And by that, I mean that Transnet attempted at that stage to ascertain what GNS had actually been doing and whether it had actually rendered services to Transnet. And it became immediately apparent that there were serious questions over whether it had actually done what it was contracted to do and what it had been paid for. And that's a piece that I can explain.
Perhaps we could start, if we have a look at paragraph 37 at page 61. At little a, you then make reference to the contract, which is attached as G.
Yes.
Could I take you to Annex G, that you find at page 110, and you go on to make the point that of particular significance is Annex C to this contract, which you find at page 141. And that sets out the resources that GNS were to deploy.
Yes.
Page 141.
I'm sorry, Mr. Mybeck. Initially, you said we should go to 110 and then 140.
Yes, 110 is the commencement of the contract.
Yeah.
It runs through and is signed at 136.
Yes.
And then there are a series of annexes A, B, and C. C you find, Chairperson, at page 141.
Yeah, okay.
You want to address that annexure and page, Mr. Todd?
Yes. This document is important because in the contract effectively says the services to be rendered are set out in annexures A, B, and C. And annexure C is the costing, the basis on which the cost was calculated, cost of the contract. And so annexure C sets out, it refers to a budget based on cost estimated using current resources available. The costs include disbursements and any other project-related costs, and they exclude VAT. And then it sets out the resources that are going to be allocated to each of three elements of the contract or the services. And those are explained in the contract. There's an investigations element, a monitoring and evaluation element, and an intelligence element. Overall, those are overseen by a project director, and that's at the top, project director with a cost per month of 40,000 Rand, and then a project coordinator at a cost of 25,000 Rand per month. And then under each of those three headings that I've mentioned, the resources that would be made available. In relation to investigations, a manager at 25,000 Rand a month, and then 10 investigators would be deployed at an hourly rate of 320 Rand, giving rise to a monthly cost of 537,600 Rand. And one can do the maths effectively there, that 530,000 Rand is the monthly cost of 10 investigators at a rate of 320 Rand an hour. And then that gives a total for the investigation stream of 562,000. And then the same breakdown is given for the monitoring and evaluation stream. There they have a manager at 25,000 rand, but they don't have investigators, they have researchers. And there are 8 researchers, also at 320 rand an hour, and they then result in a cost of 430,000 rand and 80. And then under the intelligence stream of this contract, again, a third manager, again at a cost of 25,000 rand a month. 8 handlers at 320 rand an hour. Now they're handling informers. So they're 8 handlers at 320,000 rand, 320 rand an hour, again leading to a monthly cost of 430,000 rand. 20 informers at 2,000 rand a month each, 40,000 rand a month, giving a total of 495 under that stream. And that leads to a subtotal of 1,577,760 rand per month, excluding VAT. So I've referred to that in some detail, Chairperson, because as it happened, this was attached to the contract, and each invoice issued for this work reflected that breakdown of those charges for the contract.
Which, or the information contained here in Annex C, including the total, and it said total per annum, would all indicate that the intention was for the contract to run for a year.
Yes.
Because otherwise, why calculate on the basis of a year if it's for 5 months? Yeah.
Yes, yes, Chair.
Okay, all right. But,
This is the number that was written into the confinement agreement as the annual cost.
yes, yes.
And then it had that sort of proviso which said, well,
Yes.
we'll review it after 5 months.
Yes. It's just difficult to understand how anybody would not have seen all of these things. Yeah,
Yes.
okay, all right.
So if you go back to page 61, you then say at little b that there were extensions. I'm going to leave that for a moment, Mr. Todd. We'll come to the detail of that when we return to your third affidavit. But then, importantly, at little c, at page 62, you talk about the fact that consideration was given to terminating the contract and that you then attended a meeting. Perhaps you could address what transpired at that meeting and thereafter leading up to the issuing of the summons
Yes.
at little e.
So the backdrop to this is that while preparing and formulating the complaint against Mr. Gama and Mr. Senamela and Mr. Kanya, who had effectively entered into this highly irregular, fraudulent, corrupt scam, whatever words are most appropriate to attach to it. The fact of the matter was that every month Transnet was paying this company at that stage around about 4.5 million rand after 2 extensions to this contract. And Transnet wanted to terminate that arrangement. So they engaged with GNS, with the company, and they set up a meeting, which I was asked to attend because I had now become familiar with all of the background facts. And they wanted to know, one of the particular concerns that Transnet had was, of course, it wasn't entirely sure whether this was just an irregular procurement, but the services were being rendered as required, or whether it was worse. And one of the things which would worse, meaning, in fact, these services weren't even being provided, or at least not as they should be. And one of the biggest alarm bells that rang for Transnet was that on a very quick analysis of GNS by the forensic investigations team, immediately transpired that GNS, in fact, had no employees at all. It had no employees. It was not even registered as a PAYE payer, and it wasn't registered with PSIRA, which is the Private Security Industry Regulatory Authority. And that was so that was the backdrop actually of the meeting that I went to, which Transnet said, look, you don't have any employees. We're paying you every month for all of these resources. What is going on? And at that meeting, GNS representatives were there and they said, well, you don't understand our business model. And so we said, well, please, we're here, explain the business model. And they said, actually, we are a platform and we operate as a platform and we procure employees from other security companies who then render services to Transnet. So we said to them, well, that's interesting to hear because your contract, and I can point to the provision, says you cannot subcontract unless you have our consent as Transnet. We've contracted with you on the basis that you are General Nyanda Security with 2 directors, wholly black owned, and you will deliver the work because of your track record in delivering services. So if you want to subcontract, you're supposed to have our permission. But let's put that aside for the moment. If you have been procuring and in fact delivering these resources through other service providers, then you'll be able to provide us with details of who those other service providers are, your contractual arrangements with them, so that we can get comfort that there are ultimately, to use colloquial language, warm bodies. There are actually people. There are managers and investigators, researchers and handlers who are actually doing the work. Because at the moment, there's just no evidence that any such people exist. And they, at that stage in the meeting, they asked for a caucus, which meant we were asked to excuse ourselves while they considered whether they would give us this information. I may mention it was quite theatrical. They had arrived at the meeting with suitcases on wheelie suitcases saying, we've got all of the information that you're asking for in all of these suitcases. And we said to them, before they had their caucus, we said to them, all we suggest, we don't all need to be in a meeting. We'll just nominate 1 or 2 of our people, and they can sit with whoever on your side can go through the information you have, and then just reconcile it and show who the people are who've been doing the work over the period of the contract that we've been paying for, and which companies have been contracted to do so. They then had a caucus, which lasted a few minutes. And when we came back into the meeting, we were told they had decided, and their attorney was present in the meeting, that they had discussed the matter with their attorney and they would not be disclosing anything to Transnet. Concerning any of the matters that we'd asked, they weren't going to disclose anything about their contractual arrangements with these other entities that had supposedly provided these services, nor were they going to disclose the details of the warm bodies or the personnel who had actually delivered the services. And they then withdrew with their suitcases of information. And as a consequence of that, Transnet gave a letter following that saying, well, we've tried to engage with you, but we're terminating your contract. And that ended the contract at the end of 25 months. Had Transnet not ended it then, the contract, their position was that it should just keep going. They thought they were doing a good job. But that's what led to the cancellation of the contract. But it also led to concerns on Transnet's side, which said not only was this contract entered into irregularly, but we're now very worried that actually what we're paying every month for might not even be being provided to us because we've been given no information by our service provider about who the people are on the job.
Mr. Todd, you mentioned a clause in the contract prohibiting subcontracting. Could I ask you please to turn to page 127, and can I direct your attention to clause 20?
Yes. That is the contract, and in fact it's not just approval, it's written approval that's needed. And I think that's a sensible, that's a standard and a sensible provision. If you contract with General Nyanda Security, you don't want to find out without your express agreement that actually somebody else is providing the job, is doing the work, otherwise you've been misled. So it requires written approval for any kind of assignment or subcontracting.
And that you see at 20.1 read with 20.1.2.
Correct.
If you go back to page 63 of your affidavit. You've now told us of the meeting, you've told us of the letter.
Just 1 second, Mr. Maybeck. I just want to make sure that my understanding of this is correct. So, in the meeting, GNS representatives told you that their business model was in effect such that they did not keep employees that would go and do the job in terms of the contract. They would subcontract and get other service providers to effectively do the job that they were supposed to do.
Yes.
But now the contract prohibited subcontracting on their part without the written approval of Transnet.
Correct.
Which therefore means that they couldn't be said to have performed in terms of the contract.
No. No, Chairperson, there's no doubt about that. They
Yes.
were on their own business statement about their business model.
Yes,
They were from the get-go in
Yes,
breach of the contract.
yes.
Or right from the beginning. But the Transnet's attitude in that meeting had been, however, let's not at this stage exercise our rights on a technicality and say you're in breach of the contract on that ground. First, let's see who these people actually are.
Yeah.
And then we can possibly decide ex post facto. We could have decided ex post facto to
Yeah.
give written consent and say, now that we've understood it. But it gave rise to other very serious concerns, one of which is raised by the chairperson of the disciplinary hearing of Senamela and Kanya, which is this not simply fronting? You hold yourself out as being an experienced company capable of delivering services. Actually, you have no track record, no staff, and you don't even tell us. You're just getting other people to come in and do the work. What are the commercial terms on which those other people are coming in to do the work? And they never had to contract with Transnet. They never even pitched with Transnet. So that's that was a very serious problem that Transnet had about this supposed business model. But at this stage, it went even further because Transnet was saying, irregular business model aside, who's actually doing the work? Have these people actually been, who are these people? We'd like to know that.
They've been to the field and done the
that
work.
even that, it's one thing to tell us that, well, you've subcontracted it, but how do we know that the work's even been done and that these people have been deployed in the field? And who are these people? And they said, well, we've got the information, but we're not going to share it with you.
So actually, what GNS did was to represent to Transnet that they had the expertise and the experience and the track record necessary for them to provide these services. But once they tell us about their business model, then it becomes clear that then they had made a misrepresentation in the first place.
Yes. Chairperson, GNS did say, and they said it later, that Transnet knew. So when we come to the litigation, and when Transnet sued for repayment of the 95.5 million it had paid to GNS rather bizarrely denied that it had ever had a contract as GNS with Transnet. And I say that's bizarre because the confinement document's in their favor and mentions no other entity, and the contract is in their favor and mentions no other entity with an express prohibition of subcontracting. But despite that, in their high court pleading, defending their claim, they said there was never a contract with GNS, our company. They said there was only a contract with something which they called the GNS Consortium. And they said that consortium represented our business model. I can explain why that is just totally inconsistent with any of the documents, but I think they felt forced to do that because at that point they'd admitted to Transnet, and they had to, that they had none of their own staff, and they had no ability themselves to deliver it. It was other companies that they needed to deliver the services.
But also I'm sure the contract didn't refer to GNS consortium, it
No.
referred to GNS.
No, yeah, correct, Chairperson, that's
Yeah.
correct.
Okay, Mr. Mybeck.
Thank you. At page 63, paragraph E, you then mention what you've already touched on, and that is that following the termination of the contract with GNS, Transnet then issued summons, and that summons and the particulars of claim are at or attached as Annex H. Perhaps I could just take you there, Mr. Todd. You find that at page 142, 142.
Yes. That was the High Court summons for repayment of 95.5 million.
And the particulars of claim commence at page 144, and then the amounts you see at page 154, the 95 million. I just wanted to ask you to address the fact that here the defendant was cited as Abalosi Risk Advisory Services.
Yes.
Why was that so?
Yes, between the period when the contract was terminated and Transnet issued summons, the legal entity, General Nyanda Security, with which Transnet had contracted, had changed its name, the company name. So it is the same company, but with a now changed name, and now it is called Abalosi Risk Advisory Services. It had been called General Nyanda Risk Advisory Services, as one can see from the contract that was concluded with them.
If I could then ask you please to go back to your third affidavit, to turn up page 489.
Yes.
So we've dealt with the signature of the confinement, you've dealt with the run-up and the issuing of the summons, and then what you go on to do in your third affidavit at page 490 is you analyze the charges as reflected in the invoices, and you deal with the initial services, and then you deal with the first extension and the second extension. You've already touched on this, but do you want to just summarize your evidence in that regard?
Yes, so if I can refer, I did take the chairperson, I showed chairperson Annex C to the contract, but what is, the point that I thought it was appropriate to make then is that when invoices were issued, and I've just attached examples that were available to me when I deposed to this affidavit, but I'm very confident because I've seen all of the invoices, they take the same or similar form. But at page 623, 623 is an example of a tax invoice for the first initial services that were contracted for with GNS. And that tax invoice shows that it shows the breakdown as in Annex C to the contract. In other words, it shows the project director, it shows the project coordinator at 25,000 Rand, and then it has the investigation stream, 562,600, the monitoring and evaluation stream at 455,080, and the intelligence stream at 495,080, giving a total of 1,577,780, to which VAT is then added to give a total of 1,798,645 for a month. But I made that point because later it was suggested that actually this contract wasn't for the particular resources specified in Annex C, that it was just a globular number and that GNS could do whatever it thought appropriate for that number to try and manage security. But it seems to me that that argument cannot be reconciled with the way in which GNS invoiced, and it's very clear that the invoice ties back to Annex C to the contract, which sets out that there is going to be a project director, a project coordinator, and in each of these three streams, a manager, 10 investigators, a manager, 8 analysts, and a manager, and 8 intelligence handlers. And so those are the resources which make up these numbers, and then this amount is invoiced to Transnet every month of the 25 months of the contract for those initial services.
And then you deal with the first extension at page 491.
Yes. So what happened once this contract had kicked off in December 2007 is that within a few months, and it's described in the document which is at page 624. It's in fact the document over the page from that invoice.
What's the page?
624, Chairperson.
Yeah, okay.
That is a document which is referred to as an extension of scope. And this was a procurement document which effectively described the background and reasons for extending the scope of GNS's contract. In effect, it was in March, I believe, with effect from March 2008. And the background to that is explained in paragraph 2 at page 624, where it says recommendation, reasons for extending the scope of work. And it says, due to theft irregularities at the Kaserne yard, and that's a yard in south of Joburg where a lot of containers and other things are stored. An appropriate decision was taken by TFR Security Management to suspend the TFR security personnel at the yard and the contractor on site, Singobile, Equestrian Security Services. So what happened was, and then it's explained, on the 14th of February 2008, a container was found outside Kaserne yard without the relevant authority. And as a result, they suspended the TFR security personnel. It was irregular that a container was outside the yard without authority, and they suspected insiders, so they suspended the Transnet's own security, and they dismissed Singobile, which was the outsourced service contractor at that yard, and they pulled in extra GNS resources. And they said the extra GNS resources will be used for the following: conclusion of the investigation for suspended TFR security employees after internal disciplinary process; 2, executing security operational functions that were previously done by those TFR security employees; and 3, escort and protect train drivers. I'm not sure why that follows from the Kaserne yard, but they explain those 3 reasons for extending the scope of this contract. But what is then important, if I may say, Chairperson, over the page, on the next page, 625, again, this procurement document describes exactly what resources are now being procured through this extension of the contract from GNS. So it says there at page 625, 16 resources at 150 Rand per hour, giving a total of 884,000 or 864,000 Rand per month for 16 resources at 150 Rand an hour. So these were now people who were going to secure the yard and escort and protect train drivers, working 12 hours for 30 days a month. And then item 2, 7 investigators. So that's 7 additional investigators. We've seen that the first leg of the contract had 8 investigators in the investigations on. This was an additional 7 investigators at 320 Rand an hour, 376,000 Rand extra a month. And they would be deployed nationally to investigate cable theft incidents linked to syndicates. Again, it's not clear why that follows from the Kaserne yard incident. It's just another 7 additional resources for the first scope of the contract. And then third item, 6 investigators, that's another 6 at 320 Rand an hour for 322,000 Rand a month, permanently dedicated to Kaserne and Kazkorn yards due to vastness of the area, working 8 hours for 21 days a month. That's explaining how the investigators, you multiply their hourly rate by 8 hours and 21 days a month. you multiply by the number of investigators, and you get 322,560 rand. And then one resource at 150 rand an hour to be deployed at electrical control room to monitor the call and reporting of incidents for 24 hours for 30 days, with a change of shift and a reliever. So this extension again specifies per person what the cost is, either on an hourly basis, so that you get to the additional monthly cost of, and it explains that they're 1,670,880 rand. So 1.6 million rand per month, additional cost. And what you then find after that is every month from this point of view, a second invoice is issued by GNS to Transnet for that amount plus VAT. And that is why I said in the affidavit that effectively doubled the value of the contract when you looked at the cost. In fact, it's slightly more than doubled the value of the contract.
If you go to paragraph 19 at page 491, that's where you set out the figure. The second invoice each month in the amount of 1,781,000.
Page 4,
491, Chairperson.
491.
Paragraph 19.
Okay. Yes, you can continue.
Then, Mr. Todd, you go on to deal with the second extension.
The second extension of services occurred about a year later, in March 2009. And the background to that is again set out in a similar procurement document. It is attached, actually there is this time it's in a letter which is at page 630 of the documents. And what it explains there is, and what I can go into the detail, but this was actually ex post facto, what had happened after the event. What had happened was that an additional resources had been procured from GNS, but they hadn't been regularized through a procurement process. And this letter asked for, this letter is dated in May, it's the 12th of May 2009. And it's actually explaining why additional resources have been procured from GNS and asking for those to be approved. And the background to this is that on the 28th of February 2009, a Mr. Herbert Msagala, who one can see, I think later on, he approves it as the General Manager for Resource Management at that stage in TFR. Herbert Msagala, General Manager Resource Management. He received a message that a train crew driver had gone missing with a company official vehicle without a trace. And this was described as a security risk, as a hijacking of a Transnet employee, and that this person never turned up again. And some of the documents, I'm not able to say what the detail is, but there was a reference in the documents to this person being presumed dead, which was regarded as a very serious risk to train crew and train drivers. And so what they did was they acquired additional resources from GNS. And the additional resources from GNS are then explained. They wanted armed vehicle escort officials and security to give train crew management protection. And that led to an additional amount of 856,800 rand due to GNS excluding VAT per month. So that extended the contract by a further amount. An example of the invoices over the page.
So can I just confirm, so the additional resources that were required, they set out in the second paragraph of page 631. The required resources, as you said, are armed vehicle escort officials and security to give train crew management. Were those the additional resources?
Yes, that's what this letter says, but the invoice that was rendered for March, they refer to the March 2009, and that amount of 856,800 excluding VAT being due. That very invoice one can see over the page at 633, which then sets out how those resources are in fact made up. So at page 633, that's an invoice dated 25th of March 2009. And there you see the resources there. What is being invoiced for are 2 supervisors at a total monthly cost of 108,000 Rand and 16 train crew monitors and rapid response at a total cost of 748,800.
Again, warm bodies.
Those are exactly warm body, 16 people. And this is in addition to the earlier extension, which I referred to, which had involved, also involved 16 resources to secure the yard and escort and protect train drivers. So this was an additional 16 over and above the 16 that had been procured a year earlier and were being provided every month. So an additional 16 train crew monitors and rapid response at that cost of 748,000, giving another monthly cost of 856, with VAT amounting to 975,752. And that again became a third invoice. From that point onwards, a third invoice was rendered every month to Transnet. And that it was those 3 invoices together by this stage that cumulatively was approximately 4.5 million Rand a month.
So that you deal with at paragraph 25 of your affidavit at page 492. There, payments of services initially procured, that's the 1.7 million, then the first extension, another 1.7, and then the second extension, the 976.
Correct.
And you go on to say that that's, in effect, how you computed the claim of 95 million.
Yes, that's correct. And what Transnet, I've included, it was provided to me by Transnet. I've got no reason to doubt it's correct. It's from their payment ledger, from their SAP system, which shows that throughout the whole period of this contract, 3 invoices were rendered, well, not for the whole period. From the beginning, the first invoice was rendered, and once the extension was granted from that month, a second invoice was rendered every month, and then when the second extension, a third invoice was rendered every month from that point onwards. But the amounts remained the same in each of those invoices.
Mr. Todd, at page 493, you then deal with Abelosi's plea and counterclaims. Do you want to summarize that for us, please?
Yes, I've attached the documents themselves. There were various technical points raised, and I've mentioned one of them already, which is they put in a plea of misjoinder or non-joinder, and there they said, you've sued the wrong person. GNS, or now Abelosi Pty Limited, was never the counterparty. The GNS consortium was the counterparty. And that, as I've already dealt with, it's an odd thing to say, both because a consortium is not a legal entity, and secondly, there was no contract with the consortium. The contract all along was with GNS, now known as Abelosi. But that became central to the defense. Throughout the plea, they say it's the GNS consortium. And they mentioned 2 other companies which they say were part of the GNS consortium, which they name. And yeah, in essence, what they do is say the consortium has been doing what it was asked to do. The invoices, I mean, again, the invoices have all along been rendered by GNS, the company. There's no suggestion that any other entity was involved. But perhaps the most significant thing to say then is about their counterclaim, because what Abelosi did is said, you suing me for 95.5 million, while I'm counterclaiming for something close to 500 million for damages which have been caused to me by your conduct, because you've cancelled my contract, and this has created reputational harm to me. I've lost various other contracts in the public sector, and we've lost various other hoped-for contracts, and in total we've suffered damages of, when you add it all up, it's very poorly pleaded, and it's difficult to make out exactly what they're claiming. But it amounts to in the 400 millions as counterclaims, which they say they're bringing against Transnet.
But you say you attach that document, that's as Annexure R. One
Yes, that's
finds
correct.
it at page 636, is that correct?
Correct.
Running through to page 661.
Yes.
All right. Then if we can turn to the next main topic, and that is Transnet's decision not to pursue the claim
Yes.
that you deal with at page 495, commencing at paragraph 32. Please take us through that.
Yes. Just the context for that, Chairperson, if I may say, is when I was dealing with the reinstatement of Mr. Gama, one of the points I made is that a reinstatement of somebody in these circumstances has consequences. And one of the consequences, if you follow through, is what happens in a case like this. And so what we then deal with is that you've now reinstated a chief executive who was charged with the conclusion of this contract in an inappropriate, ultimately found guilty of negligently, and he admitted acting with serious negligence in entering into this contract. He's been reinstated
I think he was lucky.
into the business.
I think he was lucky that the chairperson didn't find that he had intentionally.
Yes. But in the course of doing so, as I've shown from the transcript, he says that effectively this was a fraud, a scam, the contract should never have been concluded. So one might have expected the very first thing on his desk when he was reinstated to say, let's get that money back. It was all a fraud, a scam, inappropriate, the wrong thing was done here. But in fact, what happens over a period of time, as we see, is that the management within TFR, which Mr. Gama is again leading, now starts to say, actually, there's no reason to sue these people. And I'm paraphrasing. But they said, and I really then set out what, through the minutes that were given to me, we represented Transnet in the litigation. And there were long periods of silence when we had no instructions and nothing was really happening. But then we got requests to say, we've had monthly reports from them about the services they've rendered. Doesn't that show that they actually did the work? And then we had another thing which, and really that's what this section of the affidavit takes you through. So the Transnet, the management team, over which Mr. Gama now presided, started to say, and I say it's the management team, it's one manager in particular, under Mr. Gama, started to say, well, the work was done. There's no problem here. So why are we suing them? That's really, I'm paraphrasing.
All right, and then you mention along the way at paragraph 37, at page 496, that there was a time where you were asked to obtain counsel's opinion.
Yes.
Just address that, please.
Well, the backdrop to that is you can see that in April 2012, and the minute is there's a risk committee meeting, which shows that the management team so now you have members of the board interacting with members of the management team. Board subcommittees, the risk committee, which has got a long agenda. One of the items on its agenda is that Transnet is suing Abalozi for the repayment of 95.5 million, and Abalozi has counterclaims. And the management team say, well, we've actually now, what's reflected in the minute, and I, of course, wasn't at the meeting, I can only read the minute. And the minute says, members of the management team inform members of the risk committee that they've uncovered information that hadn't been available in the past, and that we may not actually have a case against Abalozi. And what then happens is, in September of that year, Mr. Ndapiwa Salinga is the legal advisor within Transnet who's responsible for managing this litigation. He's a general manager for legal services. And Mr. Salinga gets a memorandum, and we've attached an email which we were provided with by Transnet. I've been provided with it by Transnet. I haven't, again, it's part of Transnet providing me in its capacity as a legal advisor with information internally. But that email says, well, we've now got a monthly report for every month, each of the 25 months that Abalozi rendered services, GNS rendered services. We've got a written report setting out what they did. Doesn't that prove that they did the work and we shouldn't be suing for the 95.5 million? And so what Bowman Gilfillan was then instructed to do was to get counsel's opinion on whether the existence of these monthly reports, had a material impact on the case. And effectively, counsel gave opinion. I've included it as an annexure to the affidavit and said, well, this doesn't change it at all. It doesn't really show what services were actually provided. And it's possible if GNS Abalozi comes along in the litigation and says, we can prove that we deployed resources on Transnet business. As we deployed 16 train crew rapid response. Here's the evidence that they were deployed. Here's the evidence of the people who actually worked. There could be some reduction in the amount claimed. There's still an argument that the procurement was irregular from the start, and so it must be repaid. But there's a possibility that if GNS could prove that they actually rendered services, that might reduce the amount of the that we would claim. But up until this point, and really it continued until this day, GNS had never produced any evidence of those warm bodies, those 16 train crew, and the next 16 train crew. They never produced the names and the entities and the contracts under which those people were provided, and they never had.
And they had all the opportunity to produce those names.
They had all of that opportunity before the contract was cancelled, once the litigation started, in the discovery process. They never produced that information. So it remained a big question mark, and really what then became a question is, well, they've got these monthly reports saying, we've done all this work. Now, that monthly report either is a true reflection, what they should have said is not just, this is our report, but here is the list of people who we deployed, and here are our timesheets. That would have been a good start. But they never did that. They produced monthly reports, but those reports could also simply have been a desktop analysis produced by one person.
But they had been asked before the contract was terminated to produce such information, and they didn't produce it.
No.
And took the risk that the contract would be terminated because they didn't produce the information. So one asked the question, if they had that information, and they had actually got some companies to provide the services, why would they not have given you the information in order to avoid the cancellation of the contract?
Yes, Chairperson. It would have been the obvious thing to do. And it would have been the obvious thing to do when they were sued as well for repayment.
Yes.
They never did it.
But now the reports that were said to exist, now that was being said by some people within TFR after Mr. Gama had been reinstated?
Yes.
That had not been said in the meantime, and the contract was terminated early in 2010, is it?
Yes, in January.
In January 2010. So, and Mr. Gama came back to the company in April 2011. So, for more than a year after the contract had been terminated, they never placed before Transnet that information to say, here is the information. And then after Mr. Gama had come back, suddenly managers under him began to say, Transnet might not have a case against GNS.
Yes. Chairperson, GNS had produced irregularly reports. They were required to provide a monthly account of what they had done.
Yes.
But those reports, and there are versions of them, and they become relevant because they were subjected to close analysis later.
Yes. Yes.
Before Transnet ultimately settled this case. They are monthly reports of the kind which describe what activities generally have been conducted, what investigations are ongoing, and what police cases have been opened for criminal conduct, and so on. So, as I've said, they could be a good summary of what's going on with the actual deployment of 10 investigators, 8 researchers, 8 handlers, 16 train crew, and so on. But you would still expect to see some evidence that those people were actually deployed in the field. Because if they weren't deployed in the field, those reports could equally have been produced by somebody sitting at a desk, plagiarizing other reports and simply writing up fantasy about what's been going on. So in other words, the reports themselves looked like a narrative of services that were being provided, but they weren't evidence that in fact those services had been provided, and particularly where Transnet was paying for all of these warm bodies, those resources in the field, and there was no evidence that those people existed, and GNS had never provided that evidence. So it was a worry that those reports simply reflected, anybody can write, oh, I've been working really hard this month, and this is what we've been doing, but it proved that that work had actually been done.
Yes. Mr. Molefe.
Thank you. At paragraph 39, page 497, you then deal with what becomes quite a significant event, and that is the memorandum produced by Mr. Tetwa that was copied to Mr. Gama on the 14th of January. Please deal with that.
Yes, just to round off, after Council's opinion said these reports are not sufficient, you can see that Mr. Salinga then sends a memorandum to his superior, Ms. Mabandla, who was the Group Executive for Legal Services at that time, and says, and this is at page 497, I've actually quoted from the memorandum, which is Annexure V, which is at page
677.
677. Thank you. So the memorandum itself is at page 678, I think. Yes, sorry. It's at page 677, thank you. There is a memorandum from Mr. Salinga, it's in December 2012, saying, having received various monthly reports which were intended to demonstrate that Abalozi did in fact render security services to TFR. So having received various monthly reports which were intended to demonstrate that Abalozi did in fact render security services, that explains what was the intention of these reports. These reports were trying to show, yes, they did do the work. Group Legal was requested to obtain a brief opinion from Council on whether or not the reports would be sufficient to demonstrate that Abalozi had indeed performed in terms of the agreement. And if so, whether Transnet would be justified in withdrawing the action it instituted against Abalozi. The language is interesting. It's would it be justified in withdrawing the action it instituted, not whether it would be wise or whether it would be whether it was likely to lose the case. It's just whether this would constitute a good enough reason to withdraw the case. Anyway, the Council's opinion was there's an opinion given, and the opinion is there's no reason to withdraw. But very soon after that, from a time, that's December 2012, the very following month, in January 2013, a memorandum appears from Mr. Sizam Tetwa, who at that stage was the General Manager Rail Network. And he sent a memorandum to Ms. Mabandla and copied it to Mr. Gama. And that is the memorandum which is at page
678.
678. Now, so that's January 2013. Mr. Tetwa writes a memorandum, and he says the purpose of this memorandum is to provide feedback on the performance of GNS risk advisory services and the cost of services they provided in comparison to the current service provider. And in a nutshell, what Mr. Tetwa does in that memorandum is he says, if you analyze cable theft loss per month in the period before GNS was appointed, when we had a couple of months where we had no security provider, and then when GNS provided their services, and you analyze monthly cable theft, and then you analyze it now with a new security provider where we're actually paying a lot more. Overall, he says, actually, we got a very good deal with GNS, and I'm paraphrasing. That's what Mr. Tetwa says. It's basically an analysis of the length of copper cable stolen per month in kilometers, and he sets that out in his memorandum. Now, and he says, in his conclusion, which is at page 681, he says, it's evident from the performance statistics that the use of specialized security services produced positive results in combating copper cable theft. The period at which TFR did not have the service being provided resulted in copper theft deteriorating significantly. The cost comparison reveals that, and that was the period between February and April 2010. The cost comparison reveals that CPI ARM is being paid almost twice what GNS was paid monthly. The aforementioned facts refute the two claims made that GNS was overpaid and paid for work they did not perform. And then he said, I would have asserted these facts if anybody had asked me. Unfortunately, I was never made part of the investigation or told of the claims. So what Mr. Tetwa says, he says, I'm not looking at whether any warm bodies were deployed in the field. I'm not looking at train crew. I'm not looking at the Kusoni yard and the protection of other assets. I'm just looking at cable theft. And if I look at cable theft, I think that GNS did a good job. That's what he says. If I look at the cable theft statistics. And so, having been sent the monthly reports to say, is this a justification to withdraw the claim? In January, us as attorneys are sent this report and said, but Mr. Tetwa says that actually we got good value for money from GNS. Is that a reason to withdraw the claim? And I'm again paraphrasing what is said. But that is really the next instruction that comes, is that we get asked to see counsel's opinion on whether or not the memorandum from Mr. Tetwa will change the game in terms of the litigation.
And do you then obtain a further opinion from counsel?
Yes. Let's have a look.
Annexure Y at page 689, is it?
Yeah, I mean, I've jumped a step because actually what happened was after Mr. Tetwa's memorandum in January 2013, before going to the attorneys, there's a meeting of the risk committee again, where management again say there's a need to review the decision to litigate in Transnet versus Abalozi Risk Advisory Services. So management are again saying we've got, this is new, and there's a new issue which shows that we perhaps should review our decision to be suing Abalozi.
That you deal with at paragraph 40.
Yes, correct. Right. And then we were then asked to brief counsel and did so, and as you say, the counsel provided a further memorandum, and that's at page
689.
689.
And what was the upshot of counsel's advice?
Yeah. What counsel's advice is, it's not equivocal. But what counsel says in that memorandum, I haven't read it right now, but is, look, this may indicate that some services were rendered, may indicate that Transnet derived some value from GNS. If GNS did in fact help to curb cable theft, that may become an indication of value that mitigates or militates against the amount, the quantum that's being claimed. But he really points to a different problem, counsel does, says, I'm a bit worried here because we're advising Transnet, and our own people are telling us that who are the witnesses for Transnet in TFR who are going to say, going to be our witnesses, who are going to say that GNS didn't provide the services that they were contracted to provide. And that who's going to give the version of events here that was the basis on which we sued GNS for return of the money. And he raises that problem, and this is at page 698. He says,
he deals with that in the last sentence of paragraph 25.
Yeah, the upshot is, unless Transnet has witnesses available who are willing and able to contradict Mr. Tetwa's assertions that Transnet received fair value for the money expended, and who can do so on firm grounds, pursuing the case further would be wasteful. So counsel is now saying effectively, if we can't get somebody to stand by the arguments, the reasons, the cause of action that we've put up in the summons, and if the client itself, if Transnet itself is saying, well, the work was done, based on Mr. Tetwa's memorandum, we're going to have a problem in the litigation. And that then led to a meeting with the Group Chief Executive, Mr. Molefe, that I also described.
But just to make sure I understand this part, Mr. Tetwa's memorandum doesn't say, here is evidence that shows that GNS provided the services. It doesn't say that, but it simply says, we have looked at the statistics of cable theft, and we have seen that there was some significant reduction during the period of the contract, of the GNS contract. And I therefore think that that might be an indication that GNS did perform the services. Is that what it says in effect, or does it say more than that?
Yeah. Chairperson, I mean, you're correct with respect that the memorandum does nothing to say the various warm bodies, the resources that were being contracted from GNS were in fact provided. It actually operates on the assumption that they were and says, I can show that they were effective. That's really what the memorandum does. It doesn't say, I can confirm that 10 investigators were deployed from the outset, that another 6 were then added, that 16 people, and also it doesn't deal with the train crew point at all, that resources were or weren't provided to protect train crew. That's not dealt with in that memorandum at all. It simply deals with copper theft, and it presupposes actually that GNS were in fact delivering the resources that they had been contracted to deliver and were invoicing for.
But you said the only reports that GNS did provide at some stage were reports that did not show, in terms of the information they put forward, did not show that the services were actually provided and the people who were supposed to be stationed where they were supposed to be stationed were stationed. Right. The reports, as I understood what you were saying, could well have been prepared by somebody sitting at his desk and not having seen people actually working.
Yes.
So Mr. Tetwa's memorandum must be understood in the context of the fact that he doesn't put up evidence that says the services were actually provided, were rendered, as a matter of fact. And in circumstances where GNS itself had not provided any evidence showing that the services were, as a matter of fact, provided, all it provided was something that really didn't go that far. Is that a fair summary of that part of your evidence?
Yes, Chairperson.
Yeah. Okay. I get the impression, and you must tell me whether maybe getting that impression is not justified. I get the impression that at this time, which is after Mr. Gama had come back, had been reinstated, I get the impression that managers within his department, TFR, seemed to be going quite an extra mile to try and not have Transnet pursue its claim against the GNS.
Yes, all of the information available to me suggests that, Chairman.
Yes.
And Chairperson, and in fact, that's exactly what we then said to
Yes.
the then Group Chief Executive, Mr. Molefe, when we had a meeting with him in March of 2013.
Yes, yes.
We said that we said exactly what you've just said. We're getting the impression, we didn't mention the fact that it was post Mr. Gama's reinstatement, but we said we are not getting the management, the executive or management team within TFR appear to be more aligned with GNS's position in this litigation than Transnet's. And if that's the case, it's going to be very difficult to run this case.
Yeah, it seems that they were more concerned really about protecting GNS position than protecting Transnet's interests. Yes, Mr. Mybeck.
Thank you. You deal with your meeting with Mr. Molefe at paragraphs 42 and 43 at page 499. Perhaps you could just describe to the chairperson what Mr. Molefe informed you of at that meeting.
Yes, I mean, in essence, it's not usual that in a litigation that 95 million is perhaps a relatively large case, but we wouldn't normally deal directly with the Group Chief Executive. But we were asked as attorneys together with counsel, to attend a meeting with the Group Chief Executive. And he said to us, I need to know what's going on with this case because I am, and I'm again paraphrasing, feeling heat. I'm getting calls from this fellow. And he didn't say who he was getting calls from, but he was getting calls from somebody who was putting a lot of pressure on him to about this litigation and to withdraw the litigation.
Who was speaking, saying that?
Mr. Molefe, the group, then the Group Chief Executive.
Yes.
And so we said to him, and in effect, I've attached a note, I kept a file note at the time, which I've attached at page 699. In fact, I prepared that note in advance of the meeting because it was really a note of what I wanted to communicate to Mr. Molefe in the meeting, because we had been called there to discuss. We were getting the feeling that you've just described, Chairperson. We were getting one thing after another showing that internal managers thought that we shouldn't be pursuing the litigation. And we kept getting asked, well, does this change it? Is this a reason to withdraw? And so effectively what we communicated, and I'm confident that I communicated these were my talking points for that meeting on the 18th of March 2013. I prepared them at the time. And the points we made were, look, this contract was invalid from its foundation. It was fundamentally invalid from a procurement point of view. And it was the product of, I used the words of Mr. Gama, a scam. As to whether GNS actually did anything, it's possible if they prove so. We've asked them to show us evidence, and so far we've been given the monthly report summarizing what they say they did, but they've not given us any underlying evidence of the warm bodies deployed that we've paid for. And so it's possible if they prove that they did do valuable work for Transnet equity, to the extent that it would come into play, to the extent that a court could say, well, under some equitable remedy to reduce the amount of damages you're claiming, there are various other possible grounds on which a court could reduce a claim, but that equity might justify reducing the total amount that Transnet is repaid. If actually GNS are able to show, but these are the resources we deployed. This is what it cost us to work for Transnet. And yes, it was invalid, but we expended these amounts. Well, it might be that that would result in a reduction of the amount reclaimed by Transnet. But then, on the prospects of success, and I made this point, and I made this point very specifically to Mr. Molefe, we have to get cooperation from the Transnet executive team and a commitment to pursuing Transnet's interest in the litigation. If we, as the lawyers, are faced with instructions all the time which say, we don't think we've really got a case, we think GNS did a good job, unless we have somebody who's going to pursue Transnet's interests that it's entitled to pursue under the contract as a result of this whole exercise, then we're going to really battle to run the litigation successfully. We'll be hamstrung by the kind of instructions we get, and we said we actually would like, and we wanted him to give direction that we get given, somebody would be given clear instructions to work with us to do a proper analysis of whether we've got the witnesses we need to win the case and whether we're right. And we said in the interim, we should put GNS to the proof of their claim that they did actually render services, because they haven't satisfied us to date that they did anything. So that was effectively what we communicated to Transnet at that point in time.
You say that Mr. Molefe said he was taking heat and he was being persistently called by someone who was asking why Transnet was persisting with the litigation. Who did you think he was referring to?
I surmised that he was referring to General Nyanda, but because what the context showed, it was a powerful person that was unhappy with the litigation continuing. I can put it that way. He felt very uncomfortable about it, and he didn't mention the name, but I can't say whether it was in fact General Nyanda. It seemed logical in the context that he was referring to having been called by General Nyanda.
Then, Mr. Todd, perhaps I can just paraphrase what you deal with next so that we can come to the next important part of this. In paragraphs 45 and 46, you deal with the fact that Mr. Selinga addressed a memorandum to Mr. Molefe where he proposed or recommended the rescission of a decision really to blacklist a GNS. And that ultimately Mr. Molefe approved of that. And by blacklisting, I mean that they had, on the face of the document, been placed on a list of so-called excluded tenderers.
Yes.
Is that correct?
Yes, we weren't aware of that. There is the documents at page 700 at that stage, even before we met Mr. Molefe, internally, without recourse to us, Transnet, Mr. Selinga had recommended to Mr. Molefe, who'd approved, actually removing the bar on doing further business with, now it was called Abalozi, on grounds that really of Mr. Mtetra's memorandum, to say we're satisfied internally on the strength of Mr. Mtetra's memorandum that that actually we should uplift the bar to doing further business with Abalozi. In fact, it even includes that it was suspected that Abalozi may have colluded with some Transnet employees in order to be awarded the contract. However, there's no direct evidence to corroborate those suspicions, is what it says. Now, there was a disciplinary process in which Mr. Senamela and Mr. Kanya were dismissed, which found precisely that there was that corroboration, and that's precisely why Mr. Senamela and Mr. Kanya were dismissed. And Mr. Gama had described this procurement process as a scam and a fraud. So on what basis it is now being suggested that Mr. Gama was the chief executive of TFR at this point, but Mr. Selinga sends a memorandum to Mr. Molefe, supported by the group legal services, saying there's no reason to believe that there was anything improper in the conclusion of the contract with Abalozi, and TFR are actually happy dealing with their joint venture partners, Nail and Revert, the two security providers that were working in their consortium, and so actually we should clear them for further business with Transnet. That was done without recourse to us, and we didn't know when we went to see Mr. Molefe that was the attitude that was being pursued by the management team at the time.
Then at paragraph 47 of your affidavit, page 501, you deal with a memorandum dated the 8th of October from Mr. Gama to Mr. Molefe. Please deal with that.
There's a typographic error in paragraph 47. It's the memorandum dated the 8th October 2013, signed by Mr. Gama on the 22nd of October 2013. It says 2010. It's obviously it's that memorandum of October 2013. And really, this is the culmination of these regular meetings at risk committee of the board, and at the board where management are saying there's new information, we shouldn't be pursuing with this litigation against GNS. And so this culminates in the risk committee saying, well, somebody must come and tell us why. And so Mr. Gama pens this memorandum or approves this memorandum. He writes it to Mr. Molefe, asking for him to get a slot at a board risk committee meeting. That's at page 705. The purpose of the submission to request approval from the Group Chief Executive for TFR to present its responses to the Transnet Group Risk Committee to questions raised by the committee in respect of Abalozi Risk Advisory Services. And so what appears from that is that it says in January 2013, that memorandum says it, and this is Mr. Gama. This memorandum is prepared by Mr. Tetwa, and it's effectively signed by Mr. Gama, addressed to Mr. Molefe. And it says, in January 2013, TFR was requested to respond to the performance of GNS Risk Advisory Services and the costs in comparison to the current service provider. This was done in January 2013. One assumes that's the Tetwa memorandum being referred to. And then in October 2013, TFR was informed that the Transnet Board Risk Committee was not fully satisfied with the responses and raised the following 3 specific questions. Ascertain whether the contractual agreement was adhered to in terms of the number of security personnel required and the sites that were to be covered by the contract. So the Board Risk Committee are saying, can you actually tell us, did we actually get the security personnel that we were paying for? Report on the KPIs, which were deliverables, and reports on the investigations conducted during the contract period should be submitted to the committee. So then under discussion at page 706, the memorandum reads, in an attempt to bring this matter to finality, it's our request that the TFR General Manager Rail Network, within whose portfolio security services resides, and the TFR General Counsel address the committee in order to explain the background to the problem which the service aims to solve, the context and the nature. And it's anticipated that such discussion will add to resolving and moving the matter to closure. And let's let TFR address the Board Risk Committee. So this is Mr. Gama sponsoring, or either Mr. Tetwa, Mr. Gama asking Mr. Molefe, can we bring Mr. Tetwa and we'll explain to the Risk Committee why we say there's no reason to continue with the litigation against GNS.
Is it not strange that if GNS had actually provided security personnel at the places where they were supposed to have been provided, that there would have been nobody within Transnet who had seen that they had been there? I mean, if the city of Johannesburg contracts GNS to say, provide security services, and there must be 50 personnel during the day at the following points. Surely there must be city of Johannesburg officials who would see that those people are there.
Absolutely, Chairperson. So we'd asked GNS to provide the information of who they had posted where and when.
Yes.
They had not provided it.
Yes.
And one thing that's nowhere to be found in any of this TFR interaction with the board is any statement exactly like you've made. I can confirm that 16 train crew drivers worked for full shifts and we hired another 16, and I can confirm that those people did their shifts. There's no indication. In fact, what Mr. Tetwa then does, as we'll see, is he goes to the risk committee and he says, this is very specialized, and actually we don't pay for the resources, we pay for the outcomes. That's actually what Mr. Tetwa does to deal precisely with that problem.
Yeah, I mean, the contract is clear, provide X number of personnel.
Yes.
And you couldn't have provided personnel over a certain period and nobody from Transnet would have seen them. And it shouldn't be a problem to say, here are the points at which we provided people, and the people were working from 8 in the morning to 8 in the evening, or whatever the period, over this period. Here are even the names. And then Transnet would simply go there and say, well, who are the people who are in charge of that point? Were there people here during that time? And then they would say, yes, they were there, or they were not there.
So what TFR management did at this point is retreated into the idea that this is very specialized, and it was entirely up to GNS to decide who to deploy when and where, and we didn't, and we merely monitor the outcomes to see if we've noted a reduction in theft or something like that over that period.
But then that point or proposition seems to be inconsistent with the express terms of the agreement, which say deploy so many people.
I would agree with you, Chairperson.
Yeah. Okay, Mr. Maibek.
Thank you. Mr. Todd, you go on then at paragraphs 48 and 49, pages 502 and 503, to deal with a presentation that was prepared for the Risk Committee, and then the meeting of the Risk Committee on the 7th of November. Do you deal with those two things, please?
The presentation,
Which page are we now?
502, Chairperson.
502.
Yes.
Okay. I've got it.
and so for that October 2013, so Mr. Gama says to Mr. Molefe, can we get Mr. Tetwa an audience with the Risk Committee, and he'll explain things. So then a presentation is prepared for the Risk Committee, and I've referred to that. The presentation itself is at page 707, where it's prepared by Mr. Tetwa, and it includes in it the extract that I've referred to there, which is at page 710. And that is where, in response to the question specifically raised by the Board Risk Committee, ascertain if the contractual agreement was adhered to in terms of the number of security personnel required and the sites that were to be covered by the contract. That's the question that Mr. Tetwa was asked to address the Board subcommittee. And his response is to say, specialized security contract, different to traditional guarding contract, performance/outcomes focused, is based on a targeted reduction in theft incidents, length of cable stolen, arrests and convictions. Number and type of resources required are not prescribed to the service provider, as with guarding contracts. Now that statement, the Board subcommittee haven't read the contracts, but it's false. It's completely untrue.
Because the contract says exactly the opposite. It says specify.
Yes, and every time, when further resources are procured, which more than double the contract, the two extensions, they specifically mention the exact number, and it's not just for cable theft, it's for train crew guards, and it's for somebody to sit at supposedly to guard the Caserny yard, and it's for another set of train crew guards. So to say that the GNS contract, the number and type of resources required are not prescribed, it's completely misleading the Board, quite frankly. That's what this did. But it is something which was necessary, if I can put it that way, if you were determined to defend this contract. It's hard to know why any Transnet official would be determined to undermine Transnet's claim for recovery of money paid to GNS, but it's a logical thing to say when in fact there are no timesheets and no list of staff deployed. Then you say, oh, well, actually they didn't have to. And in fact, what he then says is the security, he in fact then goes further. He says it's a monthly project budget, reviewed and evaluated, service provider deploys resources such as investigators, researchers, and handlers at its discretion within the limit of the monthly budget and according to changing crime patterns. So what he's actually saying is they put all these numbers together, but they don't really have to deploy people like that. They can do something totally different. And the invoices say, this is how much I'm charging for, and this is who I'm charging for. And the invoices say 2 supervisors and 16 train crew. But whether they provide them or not depends on their assessment of the risk at the time of whether it's a good idea to deploy train crew or not. But they still invoice us for it. I mean, that's really what Mr. Tetwa was telling the board subcommittee, it seems to me. But it's just completely inconsistent with the contractual arrangements that had been concluded from the outset.
You might not be able to say anything about this, but I wonder whether somebody who had read the contract could put up this version without intentionally seeking to make a misrepresentation. One doesn't know whether Mr. Tetwa had read the contract.
Yes, and Chairperson read the contract and the extensions to it and understood what was
Yes, yes. And in any event, the question that he was sought to be addressed actually required the person who gives a response or an answer to have checked the contract, because the question is ascertaining if the contractual agreement was adhered to in terms of the number of security personnel required and the size that were to be covered by the contract. To answer that question, you must go to the contract.
Yes.
Okay.
Yes.
Mr.
Seems to me, Chairperson.
Mr. Mabeck?
Thank you. Then could you deal with what happened before the risk committee?
Yes.
At paragraph 49, you say that the presentation which you've just spoken of was duly made to the risk committee at a meeting on the 7th of November 2013.
Yes, I wasn't at the meeting, but I've read a minute of it. It's an approved minute of that meeting provided by Transnet. And that says that the intention, their management, again, you've got the minute recording, what did management tell the committee? And management told the committee that the intention of the exercise was to establish if there was value derived by the company from the contract or not. So they change it. They say, oh no, this is not were the personnel there or not. They say, well, did we get value from the contract? The quantum of the value derived was set out in the monthly reports and matched by invoices. So whatever that means, management are saying, if you read a monthly report saying we've done a whole lot of work for you and here's our invoice, that is proof that the invoices, the work was done. That's what management are saying. They say that the supplier was appointed to perform a data gathering function. I don't know what that means. That Abalozi adhered to the contract and that the company did not have a KPI that required the service provider to provide a list of security personnel. So management says, you know, you're asking the question, but they weren't obligated to tell us or to even have any specified number of people on the job. They just had to give us reports and give us an invoice, and that's all they needed to do.
It's a very strange situation that an entity can pay 98 million rand, 95 or 98 million rand to a service provider without being able to say, we know that the service that they were supposed to provide was rendered.
Well, it obviously is ripe for abuse, that situation, Chairperson.
Please just repeat that.
I just said it's ripe for abuse, a situation where a management team is either unable or isn't required to actually verify that services were provided. That
And maybe they were not interested in knowing.
it's a classic case where clearly a service provider can, with the right support internally, abuse that position by,
But the question then arises, the person who had the final authority to approve that these millions be paid, shouldn't he have sought proof that the services had been rendered first? So that question would arise. I would imagine that if you authorize payment of millions of taxpayers' money, the least you should do is to say, let me be satisfied that this payment is due.
yes, Chairperson.
Thank you.
Mr. Mybeck, I think we should take a short adjournment, just 10 minutes, and then we can continue. What is your assessment of how we are doing in terms of time?
I think that we should still be able to finish in the 3 hours that I indicated. If we
Yes.
take a 10-minute adjournment now, I
Yes.
hope to finish by 6:15.
Yeah, okay, no, that's fine. Let's just take a 10 minutes adjournment. We adjourn.
or anything like that. The middle portion, let's call it, of the contract, the first extension. And as regard train crew, on the basis of what Mr. Msagala said, what value can you place on a human life? We conclude that value was given to Transnet for the money paid. That's the conclusion that the attorneys reached. And they said, on balance then, Transnet got value.
That you summarize in paragraph 55 at page 505. At page 506, you then go on to mention that the risk committee then held a meeting. It was presented with these findings, and it resolved at the risk committee that the litigation against Abalosi should not be pursued.
Yep, that's correct.
And
Part of what is strange is, and maybe it's something that I mentioned earlier, is internally, Transnet is really going quite far to itself do what one would have thought they would call upon GNS to do, to say, provide us with proof. But they are doing all of that themselves. And it's like they want to find a basis to withdraw the claim. I know that when we were dealing with the question of the settlement of Mr. Gama's dismissal dispute, also there one got the impression that there was quite a serious effort to make sure that he was reinstated, no matter what. Yes, okay, Mr. Molefe.
thank you. And then at paragraph 57, you say that the Transnet board met on the same day, and you attach a copy of the minute. Could I take you there, please? That annexure is LL at page 787.
Yes.
You'll see that what you attached to your affidavit was really an extract, paragraph 7.4, under the heading Board Risk Committee. But if you drop down to 743, you'll see that it's cut off. One of the members indicated that the committee had approved the finalization of the Abalosi matter based on the findings from an independent mediator. Moreover, management had also informed, and then there's nothing after that. Mr. Todd, you have managed to procure the full minutes of that meeting, and it's apparent from the full minutes, and I'll hand up them in a moment, that the minute went on to state that management had also informed the committee that the criminal matter on Abalosi was withdrawn by the NPA due to a lack of information to prosecute. The committee requested management to compile a lessons learned document from the Abalosi challenges, and then the board noted the update. So the real decision, the actual decision, was taken by the committee and simply noted by the board. Mr. Chairperson, if I could just hand up this document, which we will formally add into the exhibit, to be marked and to be placed after page 787, marked A and B. It includes the missing sentence that I've just read.
Okay.
Could you give it to Mr. Todd as well? All right, then.
I'm sorry. This will be page 787A and 787B.
Yes, Mr. Chairperson.
Your handwriting looks to me like 75A.
I beg your pardon. 787, yes.
Yes.
All right. Now, Mr. Todd,
I'm
let's-
sorry.
yes.
So You say do they replace the current 787?
Well, the 787, as it stands,
Can remain?
is cut off, yes.
Yes.
Well, it's,
Or should we replace it?
it's,
Or
I
is it
suppose
not?
the only important page is actually 787B, Chairperson, because that contains the missing sentence.
Yes. So what do you say, finally, do we take out 787A? Or do you say
So
we
I
just
suppose that
replace?
perhaps could be the easiest way to do it, is just to add one page.
Yeah,
It's not the 787A that I've referred to, but
Yeah.
the 787B, we could turn that into 787A. And it then includes the missing sentence, and only one page needs to be added.
yes, okay. So the one you had marked as 787B becomes 787A.
That's correct, yes.
And then we slot it after page 788.
Comes after the existing 787. It'll be
Yes.
marked A.
Yes, yeah, well, it goes up to, the minutes start on 787 and then go up to 788. Eh? Yeah, 788.
Yes,
So
I
I
beg
guess
your
we'll
pardon.
slot it after that.
Yes,
And then it will be 7, or should it be 788A?
I think it's probably better to be, upon reflection, and I'm terribly sorry, 788A, yes.
Yeah. Okay. Then maybe for the record, you can just place on record what the effect is of doing this, so that whoever reads the transcript can follow.
So, Mr. Todd, just to retrace our steps, if I could ask you to go to 787,
Yes.
you see there's a report of the risk committee, and it ends off with the sentence saying that one of the members indicated that the committee had approved the finalization of the Abelosi matter based on findings from an independent mediator. Moreover, management had also informed, and if you could then go to what is now marked page 788A, it continues, informed the committee that the criminal matter on Abelosi was withdrawn by the NPA due to a lack of information to prosecute. The committee requested management to compile a lessons learned document from the Abelosi challenges, and that the board noted the update.
Yes, I can
Confirm
confirm
that.
that that is from the
Full
full,
minute.
the full version of the approved minutes provided to us by Transnet. And
Mr.
that-
Chairperson, why I asked for this and have gone to the trouble of adding it is I think it might be an important fact for the purposes of the material facts of this case, that it's really the risk committee that took the decision,
Yes.
and that's then noted by the board. I thought
Yes.
it was important to
No,
add
I
this
think it
page
is.
so that becomes clear to you.
I think it is important, yeah.
All right. Now, Mr. Todd, the decision is taken to withdraw from the litigation. And then at paragraph 58 at page 507 of your affidavit, you go on to explain that a settlement agreement was then concluded. Is that
Yes,
correct?
and the chairman
that-
drew parallels with the previous matter on which I gave evidence, but it was indeed the case that this settlement agreement too did not involve the attorneys, or Transnet did not involve the litigation attorneys who were representing it in this High Court litigation when they negotiated and concluded the settlement agreement. It was concluded without our advice.
Now, that settlement agreement you find as Annexure MM at page 789. And the terms of it are set out at 790, where it records that Transnet hereby withdraws its action against Abelosi. Abelosi hereby withdraws its counterclaim against Transnet. Transnet will, upon signature, issue a media statement in the form as agreed and attached here to marked A. And then of some significance, 4, Transnet will pay all the legal costs incurred by Abalozi, its directors, and the co-founders and directors of GNS on an attorney and own client scale. Terms of the settlement agreement are confidential and should not be disclosed to any one of the parties, to any third party. Could I just ask you to comment on paragraph 4 of the settlement, the provision dealing with costs?
Yeah, it's unusual in two respects. I mean, the first is that it purports to refer to costs of not only the company that was party to the litigation, but also its directors and the co-founders and directors of GNS, suggesting other individuals' legal costs would be covered, not just Abalozi's. But I don't know to what extent that was intended or played a role. As I say, we weren't asked to advise on it, so it is unusual. And then obviously an attorney and own client scale is what's generally referred to as a punitive scale, as if Transnet, it was somehow should be punished for having conceived of a case like this in the first place.
Yeah, as if Transnet has done something reprehensible.
And there's one other point that I just make here, is that Abalozi did withdraw its counterclaims. That's important, will appear in a moment, important for what Transnet subsequently did to settle the legal costs. And just as far as the legal costs are concerned, when you settle high court litigation like this is a matter which had only been pleaded. So any taxed bill of costs is going to be the cost, even on an attorney and own client scale, consequent on pleading the case, taking instructions and drafting the pleadings, so on and so forth. There were no preparation for trial or trial in this matter. In fact, discovery had occurred, but had on a very limited basis, and that's it.
And actually, there might not have been many witness statements that had been taken already.
Yeah, I'll comment in a moment when we deal with the legal costs themselves that were subsequently paid.
Then,
By any chance, know whose signature that is that signed on behalf of Transnet? You might or might not know, Mr.
It's consistent with other documents signed by Mr. Molefe. It appears to be signed by Mr. Molefe. I'm not a handwriting expert, but it appears to be signed by Mr. Molefe himself. And the other signature is legible, as it appears to be Sipiwe Nyanda, but that, again, I'm not a handwriting expert. It appears to say legibly that that's the person who signed that document.
Yeah.
then, Mr. Todd, you go on in your affidavit at paragraph 60 to refer to 2 letters from Abalozi, the one dated the 8th of September and the other the 16th of October. Could you just deal with those letters? You find them at pages 791 and then 793. So these are letters that were sent to Transnet after the settlement agreement.
Yes, the settlement agreement was signed apparently on the 4th of August 2014, and the following, within a month, Abalozi, or at least somebody on behalf of Abalozi, writes a letter to Transnet, to Mr. Molefe, and this is at page 791, saying the following should be taken into account in finalizing the lump sum payable to Abalozi in full and final settlement of Abalozi's legal costs.
I'm sorry, you said 791?
791.
Or you are reading from paragraph 2?
Paragraph 2, yes.
Yeah,
yes,
okay.
Chairperson.
The letter is addressed to Mr. Brian Molefe,
Yes.
and it comes from
From
Abalozi. The letters are those of Abalozi.
Abalozi Risk
Yes.
Services.
Okay, all right.
And it appears to be picking up on the obligation in paragraph 4 of the settlement agreement for Transnet to pay all legal costs incurred by Abalozi and various parties. So it says the following should be taken into account in finalizing the lump sum payable to Abalozi in full and final settlement of Abalozi's legal costs in the action instituted by Transnet and damages claimable in connection with. And then they refer to 2 other matters, neither of which I think was ever pursued. But they then say in paragraph 3, the essence of this is, in our view, an amount of 40 million rand will be reasonable compensation to Abalozi.
I'm sorry, Mr. Todd. I think the contents of that letter are important in the entirety. Could you just read it into the record? The letter at 791.
Yes. So it says, it's written without prejudice, and it says, Dear Brian, to which I take to be referring to Mr. Molefe. 1, we refer to our letter of 20 August 2014. 2, the following should be taken into account in finalizing the lump sum payable to Abalozi in full and final settlement of Abalozi's legal costs in the action instituted by Transnet and damages claimable in connection with 2.1, the pending review application, and 2.2, the pending defamation claim. 3, our view is that an amount of 40 million rand will be reasonable compensation to Abalozi in this regard. 4, as this matter has been dragging on for too long, we need your response within 7 days from today's date, failing which we will have no choice but to ask our lawyers to issue the bill of costs and proceed with the pending claims. Should our proposed settlement amount be acceptable, it should be deposited into our attorney's trust account as follows, and it gives the details of Worksman's attorney's bank account. We await to hear from you.
Thank you.
Now, Mr. Todd, perhaps I could just ask you to comment on what you know of this so-called pending review application and pending defamation claim. What did they involve?
Well, I don't know. I'll tell you what I'm able to say, that as regards the review application, I believe that after the findings in the disciplinary hearing which resulted in the dismissal of Mr. Senamela and Mr. Kanya, an article was published in a newspaper referring to those findings. And Abalozi said it was going to do two things. One was it was going to review the findings of the disciplinary chairperson. Abalozi, as an external party, was going to bring an application to review and set aside the disciplinary chairperson's findings. And secondly, they were going to sue Transnet because they held Transnet responsible for the publication of the disciplinary matter. As I don't recall whether a review application was ever brought, or if it was, it certainly wasn't pursued. And I don't believe that defamation proceedings were ever instituted. I may be wrong. I don't believe, to the best of my knowledge, our firm certainly wasn't briefed in any defamation proceedings. There's no reference to any proceedings that have been instituted. So as far as I can tell, this is reference to a threatened claim rather than one that is currently pending before the courts. But I'm not able to say more than that.
All right, and then we're also going to deal with the letter of the 16th of October that you find at 793.
Yes, so there is missing correspondence because that refers to a response from Mr. Molefe dated the 29th of September. And I did not have don't have a full picture of all of those, or a full record of the missing correspondence. But this is the stance of Abalozi after Transnet responded. And it says, if I should read this one too, Chairperson, you would like me to?
Yes.
Again, Dear Brian, your letter dated 29 September 2014 refers. 1. In reference to our letter dated 8 September 2014, we have indicated that we would request our attorney to issue the bill of cost and proceed with the review application, the defamation claims, and the director's employees' pain and suffering claims, should our proposed settlement not be acceptable. So it does appear that they are threatening additional proceedings that haven't yet been brought or certainly not proceeded with. As this matter has been dragging for so long, our consideration was that a lump sum would eliminate any further legal processes and thus swiftly conclude this matter. 3, in light of Transnet's own admissions, after appointing an external law firm which conducted a vigorous and exhaustive investigation and concluded that we were unjustly persecuted. Now, that's a rather strange thing to, sorry, I'm reading. 4, restitution and compensation would be a due remedy for the defamation of Abalozi, its employees and directors. 5, it should also be noted that prejudice was also carried over to companies which had the directors of Abalozi as members or directors in their companies, as all those companies were placed on Transnet's list of excluded tenderers. This could pose further litigation against Transnet. And 6, the consequence of Transnet's actions, including the criminal charges, have caused irreversible effects which Abalozi and its directors have suffered in the business arena. Reputations of its directors and officials were severely tainted, rendering them unemployable and not trustworthy in the sphere of security services. The nature of the company's core services requires integrity and honesty. And then 7, the following were taken into account when considering the proposed amount and exclude the counterclaims that were subject to the settlement agreement on the 4th of August. And then there's various further provisions which suggest very large counterclaims would still be brought, after including a 700 million rand defamation claims. And they then say the 40 million rand in paragraph 8, the 40 million rand proposal of settlement was believed to be a fair restitution and compensation inclusive of the legal costs incurred in all matters with Transnet. Given the extra information required by Transnet in response, letter dated 29 September 2014, and the detail of lost revenue provided in this communication, we think that a settlement of 60 million would be justifiable. It would be prudent to have this matter concluded expeditiously so as to avoid any further legal and consequential costs. We await to hear from you.
Now, Mr. Todd, if you go back to page 507 of your affidavit, after having dealt with those 2 letters, at page 61, at 508, you go on to say that you, at that time, were not aware of what actual costs were paid. Correct?
Yes.
That then takes us to your 4th affidavit. Could I ask you, please, to turn to page 798? And you say at paragraph 5, that since I deposed to that affidavit, that's the one we've just dealt with, I've been provided with certain documents by Transnet, whose authenticity I have no reason to doubt, which indicate that Transnet ultimately agreed to pay an amount of 20 million rand to Abalozi. Could you just pick up from paragraph 6, please?
Yes, thank you. Chairperson, these documents were provided to me by Transnet from its records, but they appear to reflect they come from Transnet's files, particularly reflecting payments that were actually made. And they appear to come from the financial records and other credible records of Transnet. I've got no reason to think they aren't correct. They show that, and really what the rationale for this 20 million rand payment is set out in a memorandum at page 801. Dated the 30th of January 2015, addressed by Mr. Ndapiwe Insalinga to the then Group Chief Financial Officer, Mr. Anoj Singh. And it says, the purpose of this submission is to request the Group Chief Financial Officer to authorize the payment of an amount of 20 million rand in full and final settlement of the legal disputes between Transnet and Abalozi. Then they reflect that in 2011, Abalozi sued Transnet. This was its counterclaims for damages in the sum of 487 million rand, arising out of various claims, including loss of business, loss of profit, defamation of character, and others. So those were the counterclaims in the High Court litigation. During 2014, the parties engaged in settlement negotiations, which resulted in Abalozi offering to accept an amount of 60 million rand in full and final settlement of all its claims and legal costs against Transnet per letter dated 16 October 2014. Paragraph 4, Transnet made a counter offer of 20 million rand per letter dated 16 January.
I'm sorry, I think I've lost you. I'm at 798 and 799. What page are you on?
My apologies, Chairperson. I was reading from, it's at 798, paragraph 6A, it refers to a memorandum dated 30 January
okay.
2015. That memorandum is just 2 pages further on, or 3, at 801.
Okay, no, that's all right. Continue.
And so that memorandum records that Transnet made a counter offer in paragraph 4. Transnet made a counter offer of 20 million rand in a letter of 16 January 2015, and that counter offer was accepted. And it goes on to say that it is due for payment, the effect of which will be to settle all legal disputes pending between the parties that were pending before the South Gauteng High Court, including costs. And that was then approved and paid. The letters offering the settlement amount and recording acceptance of 20 million rand are then attached to those documents.
And you refer there at page 803 to a letter from Mr. Molefe to Abalozi, where he made the offer of 20 million, which was then accepted by Abalozi, correct?
Yes, correct.
Now, Mr. Todd, just to finish off on this, could I take you back, please, to page 799? And you undertake some analysis and commentary at paragraphs 7, 8, and 9. Could you just, and 10, could you go through those, please?
So, in essence, what occurred here is that I mentioned earlier, Abalozi had formulated some very broad-ranging counterclaims against Transnet in response to Transnet's claim of 95.5 million. So in its plea and counterclaims referred to earlier, it formulated broad-ranging counterclaims against Transnet totaling in the 400 millions. When the deed of settlement recorded that their counterclaims were withdrawn, thus terminating litigation in relation to those counterclaims. And what I have said in paragraph 7A at page 799 is that having withdrawn its counterclaims, on any reasonable assumption, the deed of settlement, that settlement agreement, compromised each of the elements of the counterclaim that was set out in paragraphs 26 to 31 of the Abalozi plea and counterclaim. So this is back in 2011, Abalozi formulates wide-ranging counterclaims against Transnet, and then it compromises them and withdraws them. And Transnet pays legal costs. What immediately happens, so Transnet's legal costs, and I then deal with what legal costs actually would be. I've said on reasonable assumptions that tax costs would not have exceeded 1 million rand. That would be extraordinarily generous for a case that didn't even go to trial.
I was thinking that would be quite generous.
It's more likely to be in the low hundreds of thousands at most, since it's on an attorney and client scale. But whatever it is, you're not going above 1 million rand. And so, on what conceivable basis could Abalozi claim 40 million or 60 million, and would Transnet offer 20 million? And what appears to be in the case, effectively, is that Abalozi re-threatened proceedings that had, in 2015, re-threatened proceedings that had been compromised already introduced in litigation back in 2011. And, I say in paragraph 9, either somebody is suggesting that 20 million is a fair assessment of legal costs. That's absurd. Can't be. So therefore, the overwhelming portion of that must be a payment to compromise afresh what has already been withdrawn. Alternatively, if they say, and to the extent that Abalozi says, well, we could have brought new claims that weren't within our counterclaims, then the point I make is that this is 4 years later, 5 years after these events. Any claims of that nature that weren't included in the counterclaims have long since prescribed under our ordinary legal principles. So Transnet's apparently acting without legal advice at this point in time. There's
That
no
on its
indication.
own is quite strange.
This is not on the advice of, there's no evidence on any of these documents that there was any other law firm involved advising Transnet. These are 20 million offered just by a letter in one line by the group chief executive. In the letter at page 803. And so it's just, it's inexplicable
It's
on any
just
legal
like
basis.
some people at Transnet decided to give GNS or Abalozi some millions of rands for nothing.
There was no
It's
legal
just like
causa.
they just decided they should get some millions of rands. And it's strange that we know that in regard to Mr. Gama's dismissal matter, they had attorneys, different attorneys representing them at different times. But it's quite strange that here they seem to have decided we will deal with this without any external attorneys. And they then purport to settle either claims that had been withdrawn already or claims that may have been threatened. It is quite strange. It's like somebody just decided they need to be paid. GNS or Abalozi needed to be paid some millions of rands from Transnet.
Yes, Chairperson. To me, I can see no legal, I use the word causa, no legal cause for having paid anything remotely resembling this, and the sensible thing, if anybody had asked for legal advice, would have been for them to get a bill of costs drawn, which they had undertaken in terms of paragraph 4 of the settlement agreement. They draw a bill of costs and we'll pay that.
You have the claim, Transnet's claim, which is against Abalozi or GNS, connected with the GNS contract that is being withdrawn in circumstances where it's quite clear that the contract was irregular. Of course, as you said, Mr. Todd, maybe there could be an argument that if they did render the service, maybe in terms of equity, the amount that Transnet was claiming could be reduced. But they had ample opportunity to provide proof to Transnet that there were services that were actually rendered. They have failed to do that. And then the matter is settled, and it's settled on a basis that includes that Transnet must not only pay them costs, but they must pay them costs on an attorney and client scale. I'm not going to say that's unheard of, because I think I've heard of similar settlement in this commission involving one or other SOE, So it's settled on a basis that's very, very favorable to Abalozi and very detrimental to Transnet.
Yes, Chair.
Usually, if a matter is settled, very often each party pays its own costs. But the Transnet must pay not only the cost, but on attaining client scale. And then Transnet must pay, what, 40 million rand? Mr. Molefe?
Thank you.
Yeah.
Mr. Todd, let's then turn to the other leg of your evidence. This relates to the third payment of legal costs made to Mr. Gama or his attorneys after his reinstatement. You deal with this issue in your fifth affidavit, which commences at page 841. Perhaps I could ask you to turn to paragraph 6.
Yes.
What you do in paragraph 6 is you summarize the position in relation to the first two payments. Of course, the chairperson has heard this evidence before, but just to place what you're going to deal with afterwards in context and for the sake of the public, could you just summarize what the state of play was before the third payment was made?
So before the third payment was made, two previous payments had been made, payments 1 and 2. Payment 1 was 75% of Transnet's costs for two different legal teams, which was not regulated by the settlement agreement, shouldn't have been paid, completely irrational. No lawyer could sensibly have suggested that that amount was payable or should be paid. It should never have been paid, but it was, in the amount of R1,000,016 in legal costs. Second payment was 1.7 million rand, and that was 75% of a privately taxed bill presented by Mr. Gama's attorneys, Langer attorneys. Langer attorneys had in fact presented a bill of some 4.2 million rand, and Transnet had appointed a private taxing person, an attorney who's experienced in costs, to tax that bill and assess it. And she had concluded that it should be reduced to 2.293 million rand. That was the second payment, was 75% of that taxed amount. Now, what is significant about that is Transnet, even in dealing with that bill, effectively accepted that it would pay, that bill covered high court litigation costs and the disciplinary hearing costs and the bargaining council costs. The settlement agreement only required Transnet to pay the high court litigation costs and the bargaining council costs. The disciplinary hearing was in fact the greatest portion of the costs in the bill presented by Langer attorneys, but Transnet in fact heard the evidence of Mr. Mapoma saying, oh, well, we thought the disciplinary hearing costs were included in bargaining council costs. So Transnet paid 75% of the full amount of the costs incurred by Mr. Gama throughout, from start to finish, for the High Court litigation, the disciplinary matter, and the bargaining council. Now,
Sorry, just before you get then to the third payment, can you just confirm, you deal with this at paragraph G at page 844, that the first payment was made in March 2011 and then the second payment in June of 2011?
Yes, that's correct. That's what Transnet's records show. I just want to say one thing further on the cost consultant, if I may, Chairperson. She did provide a detailed memorandum when she was dealing with the Langer bill presented of 4.25 million. And she taxed it, she sort of gave and assessed it and said the amount that should be allowed is 2.2 million rand. This is apropos of the second payment. Quite apart from the point that it covers the whole disciplinary matter, which she was not apprised or told that it should be excluded. But she included a commentary at the end of her assessment of that bill. And it is included as an attachment to the papers. It is in a letter that she wrote, dated, which is at page 848, where she returned the marked bill of costs. And at page 853, after concluding that what should be allowed is 2.2 million rand, she says, when the above figures are considered, kindly bear in mind that as per my instructions, I marked the bill as liberally as I thought possible. As per my instructions, I marked the bill as liberally as I thought possible, taking into consideration the difficulty of the matter, the importance to the client, and the fact that the agreement stated that the respondent agrees to payment of fees and disbursements as between attorney and own client. However, taking into consideration all of the above factors, it is still my respectful view that the bill, especially as far as fees are concerned, has been substantially inflated. Should this matter ever proceed to assessment or taxation, in my experience, the figures set out herein before will undoubtedly be reduced even more. That's what Transnet is told by the tax consultant who it hires to assess the 4.2 million rand bill presented by Mr. Langa. And she says 2.2 million can be allowed on this very generous basis, and Transnet duly pays, under the settlement agreement, 75% of 2.2 million. And that is the second payment in an amount of 1.7 million. So it's now paid 1 million that it should never have paid, and 1.7 million, which is a very generous interpretation on any basis of what it should have paid.
All right, and then can you pick up?
Who had instructed this tax consultant? Was it Mr. Gama's attorneys or Transnet?
She appears to be
I wonder
writing
who-
to Mr. Gule. I say that because she writes to Sabu
So it must be.
at the beginning, but I don't know. I know that the NACE rates were at that stage advising.
Well, I'm trying to understand who it is that must have given her the instructions to mark the bill as liberally as possible. So if the instructions came from Mr. Gule, then that means probably that's where that came from.
Appears to be the case. But it is a clear indication that Transnet was, to use a colloquialism, bending over backwards to try and
So
be as generous as possible.
I guess maybe Mr. Gule had been instructed by somebody at Transnet that tell the consultant to mark the bill as liberally as possible.
Appears to be the case.
Yeah. Yes, Mr. Mybeck.
Yes, so, Mr. Todd, can you then pick up from paragraph 7 where you deal with the third payment?
But I'm sorry, but I think another point that you wanted to make, you did make, Mr. Todd, is that it's important to note the tax consultant's last point, namely that she thought that if this was taken to taxation, the amount it would likely be reduced further.
Yes.
Yeah,
I think she said significantly further.
significantly.
Well, no, she just said will undoubtedly be reduced even more.
Yes.
Yeah.
And Transnet appears to decide to pay 75% of that without seeking any further reduction that they might have sought through proper taxation.
Yes. They paid 75% of that amount 3 days later.
Yes. Mr. Mybeck.
Yes, thank you. So, Mr. Todd, that takes us to paragraph 7 and the third payment.
Yes. For a reason that is, I have no idea what the reason is. I can only point to the facts based on documents provided by Transnet. 3 years later, so the first payment is made in March 2011. It shouldn't have been made, but it was. The second payment is made in June 2011 on the basis we've just discussed. For some reason, nearly 4 years later, the records show that Transnet made I know the circumstances in which it was made, but for some reason it was raised 4 years later, and resulting in Transnet making a third payment. And that third payment is another just under 1.4 million, 1.399 million to Langer attorneys. And when I deposed to this affidavit, Transnet had dug out the documents which showed how that happened. And it arose because in June 2014, Langer attorneys wrote to new attorneys representing Transnet, in circumstances which I don't know, saying there's an outstanding costs issue. We're still owed money by Transnet. So it's been paid on any reasonable assessment $1 million too much, and probably a lot more than $1 million too much. But it's writing 3 years later to Transnet or its attorneys saying we're still owed money for costs arising out of the Gama settlement. And the basis of that is explained in a letter from Langer attorneys, which is at page 854. And essentially, what they're saying, they're going back to their original bill of 4.2 million. And they're saying, and this is at paragraph 7 on page 855. Langer attorneys write and say, our bill was actually 4.244 million. 75% of that is 3.183 million. We were paid 1.7, therefore we're still owed 1.4. For whatever reason, nobody has told Ngiza Horner, which are the firm of attorneys then representing Transnet, about the previous taxation and work that was
where
done
the amount was reduced.
by Transnet's taxing consultant, it appears, because they then appoint a new tax consultant to look at this. And there are some, quite frankly, when one reads the correspondence that follows, it's almost impossible to work out how this happens. But the new tax consultant says an amount of 776,000 Rand is still due. And Langer attorneys say, okay, we'll accept that provided you add interest at 15.5% compounded over the last 3 or 4 years. And Transnet says, fine. And it takes the 770,000 that the new tax consultant says should still be paid to them, and it adds interest in about 3 million Rands worth of interest. And, sorry, not 3 million, my apologies. Takes the amount up to 1.3 million. And that is the amount that's then paid as a third payment. So effectively the amount is taken up from 770,000, which the new taxing consultant says is still due, and that is rolled up with interest at 15.5% compounded over around about 4 years, and that takes it up to 1,399, just under 1.4 million.
I note that in their letter of 5 June 2014, which appears at page 854, you have referred us to the letter. In paragraph 2, Langer attorneys say, we confirm that when this matter was settled, that is the Gama matter,
Yes.
it was agreed in writing with the then Minister of Public Enterprises that the costs incurred by Mr. Gama would be borne by Transnet. Now, that's interesting for certain reasons. So there must be some letter that they are talking about, maybe to the then Minister of Public Enterprises, who would have been Mr. Gama at the time, of the settlement of the Gama matter 2011. So it would
Yes,
be,
it's not clear why he doesn't just refer to the settlement agreement, because the settlement agreement provides for Transnet to pay 75% of the costs incurred. But
Yes.
it's not sure why, in writing to Ningizo Horner, Mr. Langer Attorneys is now calling the authority of the minister as somehow being the authority under which these legal costs are now claimed.
well, I think Mr. Maibek and I will appreciate the significance of this paragraph in regard to the entire Gama matter. Yes, he's not referring to the settlement agreement, I think. Seems to refer to something that was, according to him, between them and the then Minister of Public Enterprises, Mr. Maibek.
Yes, thank you. Now, Mr. Todd, you've given us sort of a high-level overview then of this. The correspondence and the like is addressed in the balance of your affidavit and attached. Perhaps I could just take you to what was the final authorization that you find at page 877, Annexure M.
Yes.
It being a memorandum from Mr. Selinga to Mr. Singh, in which it was recommended that this 1.399 million be paid, that you see at paragraph 10 at page 878. And then over the page, you see that Mr. Singh ultimately approved that, and we know that that amount was paid.
Yes. What is obviously surprising is that Ndapiwe Selinga, by my recollection, was in fact dealing with the matter in 2011 as well, but I may be mistaken. It would be it's just surprising that he wouldn't refer to the previous taxation that had happened, but I can't recall whether or not he was apprised of the 2011 taxation. I would have thought he was.
I think his name does get mentioned much earlier than 2015, and it may be that he was mentioned in 2011 as well. Well, I see in clause 10 at page 878 that that clause says, or that paragraph says, Transnet is liable to pay 1.3 million rand, being the 75% amount taxed and allowed plus interest. That must be factually incorrect, isn't it? Because there were no costs that were taxed. Because taxed must mean taxed by a taxing master, taxing mistress, isn't it?
Yes.
In court.
Chair, and also just the factual statement that Transnet is liable to pay it. I mean, again, this is obviously his opinion. It doesn't appear to be.
Yeah.
It's his opinion, presumably interpreting the original settlement agreement.
Yeah.
But just as I understand it, Mr. Todd, there was an attempt at this time to re-tax that bill.
Well, Transnet appointed new lawyers who hadn't
Yeah.
been involved previously,
Yes.
and they sought to re-tax the bill without reference to the work that had been done previously
Correct.
by a Transnet taxing consultant.
And as I understand it, if I could take you please to page 860, that then is the memorandum of the the new taxing consultant, for want of a better term.
Yes, that's correct.
And that gets one to the 776, and it was interest that was added to that that gets one to the 1.3.
That's correct. That's a correct, Chairperson.
Mr. Chairperson, unless you have any questions, that completes our examination.
Yes, thank you. Mr. Todd, are you able to express any view about whether there were proper grounds for Transnet to settle its claim against GNS or Abalozi in relation to the GNS contract on the terms on which it did, or is that something you would prefer not to express any view on?
Chairperson, my view expressed throughout on the basis of our assessment of the merits of that case, together with counsel, was that Transnet had strong grounds to recover all, or at least a substantial portion, of the 95.5 million. There are reasons to compromise litigation, where there's litigation risk. We had flagged the problem of having an executive which was chipping away or undermining the case rather than supporting it, which presents litigation risk. But a properly motivated case based on the contractual entitlements of Transnet, if run properly, in our view, should have been successful. If you choose to compromise a case because there are some weaknesses or there's some risk associated with it, or if Abalozi GNS had come to the party and demonstrated that although the origins of the contract were unlawful, it had put in a lot of resources and this is what had been paid and these were the people who had done the work, then an appropriate discount or settlement or compromise could have been reached that took that into account. But I can say in my view, there were no grounds for Transnet, no good grounds on which Transnet should have abandoned its claim for 95.5 million altogether,
Yes.
and certainly not to settle it on effectively punitive terms, and most extraordinarily to then on top of that pay Abalozi 20 million rand ostensibly for claims that it had already compromised. So really it is a most unusual set of circumstances which indicates a state of mind of a party to litigation that is more interested. It's not financially motivated. It's not motivated by the financial interests of Transnet. I think that must be clear.
The 20 million rand, did it go beyond just the legal costs? Did it involve other claims that were kind of questionable as well? Or was there a separate amount for those?
Well, Abalozi had laid out its stall against Transnet, its complaints and claims against Transnet fully in its counterclaims. They included reference to defamation, reputational harm, lost contracts, lost economic value, the whole gamut. And that was in 2011. When the claim was settled in, is it 2014 or
2014, 2015.
2015. There are no live claims.
They withdrew their
their counterclaims, and there were no other live claims. But what
Yes.
Abalozi did immediately is said, on the costs, unless you pay us 40 million, we're going to bring a whole lot of new claims against you.
And they couldn't have, Abalozi couldn't revive claims that they had withdrawn.
No, the claims they were threatening vaguely were either had been compromised already,
Yes.
or would have expired by
Yeah.
prescription.
Yeah,
But there was no legal advice being given to Transnet. Transnet just looked at this and said,
yeah.
let's pay them 20 million. And that's what happened.
So all in all, it would have been that 95 million of the GNS contract from 95, 98, I can't remember.
It's 95
Then
point.
now 20 million rand on top of that, 115 million altogether. Okay, no, nothing arising, Mr.
No,
Mr.
Mr. Chairperson, thank you.
Thank you very much, Mr. Todd, for coming to assist the Commission with regard to this matter. We appreciate it very much. I will now release you. You are now excused. If a need arises to ask you to come back, we will ask you to come back, but hopefully there will be no need. Thank you very much.
Thank you,
You are now excused. Mr. Maybeck, and counsel for Mr. Gama, he indicated that they were just here to observe, so I guess there is nothing. We'll adjourn now. Tomorrow, I'll continue with evidence relating to ESCOM. We'll adjourn now. We adjourn.